Hello. Am I audible and visible, dear students? Okay. Chalo. So a wonderful good afternoon to everyone. And I know that you have your exams tomorrow. So I'll be very quick with a lot of topics. I will be revising certain important topics from the point of view of our examination. Okay. Yes. So let us begin without wasting any time. Okay. So see, let me introduce myself. My name is Professor Shubham Joshi. Okay. I'm a lawyer by profession and I have teaching experience of 10 years. I know that we have exams tomorrow. So we have to, study for the examination tomorrow. We also have a lot of stress with respect to how are we going to revise everything. Today in this session, I will be taking care of all the important topics from certain chapters, okay? Because we have time constraint. It is one day before marathon. So in this marathon lecture, I will take all the important topics. I will revise all the important topics for you all. And I will also brush up certain topics which a lot of times students tend to skip, like Negotiable Instruments Act. I think as a student, a lot of us have always tried to skip that topic, correct? So our target for today is very simple. We will be seeing Constitution of India. We will be seeing Law of Torts, CPC, CRPC. Then we'll be going to Contract Act and Negotiable Instruments Act. So the target is very clear. And also if time permits, I'll complete Evidence Act as well. Okay. So our target is very clear. We will be focusing on these topics. So are you all ready? Are you all ready? Are you all ready? Show that fire in the comment section. Put that fire in the comment section. Like the video ASAP and let us begin. So today I will be starting off first with Law of Torts. And I have revision book with me. But since I don't know like how you have studied, I will be assuming that you all are preparing first and foremost. You all have this book. So this is the reason why I am referring the ICSI module. This is the module that I'll be referring. So let us begin. Ready? How's the Josh? It should be very high. Yes, that's it. That's it. That's it. That is how you all will be energetic. Correct? Yes. Now, without wasting any time, let us begin. So the first topic that we are going to see is Law of Torts. Okay. Now, we all know that this topic is actually very easy. And in this topic, they will ask us certain questions. We all know that tort is a French word. What is tort? Tort is a French word, which is English equivalent of wrong. And tort is derived from Latin word tortum. Okay, so Latin word is tortum, English word is wrong, and in English it means wrong, in French it means tort. Now in tort, you have to focus on two things. See, tort is a species of civil injury of wrong as opposed to criminal wrong. So tort is nothing but civil injury, and every civil wrong is not a tort. We will understand everything one by one, line by line in detail. I promise you one thing, whatever I make you revise, you will remember it. So first thing, elements of tort. Tort is a civil wrong. Very good. Civil wrong is not a breach of contract or breach of trust. And wrong is redressable by an action for unliquidated damages. So damage and damages. Everyone, we all know what are damages. Let us focus on kinds of tortious liability, civil wrong, and all of these things in detail. Ready everyone? Chalo. So first, like the video fast and tell me that you should write one thing in comment section. I will pass the upcoming exam in first attempt. I will pass the exam in first attempt. Okay. Now, what is the meaning of damage? Damage means legal loss or violation of legal right. So damage means infringement of legal right. And damage also means monetary, pecuniary compensation or compensation in terms of money. Further, damages will be also classified as liquidated and unliquidated damages. So what is the meaning of liquidated damages? Liquidated means prefixed damage. What is the meaning of liquidated damage? Prefixed or predetermined compensation. And unliquidated damages means which are not predetermined or decided by the parties. In law of torts, remember one thing, in law of torts, we focus mostly on unliquidated damages first, correct? In law of torts, our main focus will be on unliquidated damages because liquidated damages are something which are prefixed, and we see this in contract law. We see this in contract law, correct? We see this in contract law. We see this in contract law. Now, kinds of tortious liability and general conditions. Okay, first is civil wrong. Everyone, wrong is of two types. Wrong is of two types. Okay, I will add a page over here and I'll write everything in simple and easy way. See, wrong is of two types. Wrong is of two types. First is civil wrong Another one is criminal wrong. Criminal wrong is called as crime. Criminal wrong is called as crime. Civil wrong has a type called as tort. Civil wrong has a type called as tort. Tort has two parties. Okay. One is called as tort feasor. Tort feasor means a person who commits tort. Okay. Another one is called as plaintiff. What is the meaning of plaintiff? I will be taking the session Someshwaran till 6 o'clock. Okay. Till 6 o'clock I'll take the session. I'll try to cover as many topics as I can. I promise that. Okay. Now, first is plaintiff. Plaintiff means a person who files a case or who files a plaint. What is the meaning of plaintiff? Plaintiff means a person who files a plaint. What is the meaning of plaintiff? The one who files the case or against whom wrong has happened. Correct? Correct, everyone? Yes or no? Yes. Tort feasor is the person who commits tort, and this person will be defending himself. That is the reason why we call him as defendant. We call him as defendant. So one is plaintiff, another one is defendant. Now, in tort, there are two elements that are present. One is damnum sine injuria, which simply means damage without injury. Correct? Damage without injury. Damnum sine injuria means damage without injury. What is the meaning of damage without injury? There is a case law. Can anyone tell me the name of the case law where damage has occurred but there is no injury? The name of the case law is Gloucester Grammar School. Do you all know the case law? Fast. Do you all know the case law? Damnum sine injuria, injuria sine damnum. Do you all know the case law? Do you all know the case law? Damnum sine injuria means damage without injury, and there is a case law by the name of Gloucester Grammar School. Do you all know this case law? There was a teacher working in a school. He left the school and he started his own school. Now he charged less fees, and this school was right next to the other school. So this school tried to sue the teacher by saying that you have caused damages to us. Now the school took this person to the court. Now, when this matter went to the court, this person won the case. The teacher won the case. The teacher won the case because there was damage, but there was no injury. This means that in tort, injury is important, but only damage without injury may not be tort. Only damage without injury may not be tort. So, can I conclude over here by saying all damages are not torts? Can I conclude by saying this, that all damages are not torts? Is this crystal clear to everyone? Is this crystal clear to everyone? All damages are not torts. All damages are not torts. I hope this is crystal clear to all the students who are watching the session. Okay. I hope this is crystal clear. So, damnum sine injuria means damage without injury. It simply means that in all the cases of damages, it is not necessary that all damages will turn out to be tort. No doubt that this school faced some damages, faced some loss, but this cannot be considered as tort. Now, when we go to the next topic, the next topic is very pretty quite simple, and that topic is injuria sine damnum. What is the meaning of injuria sine damnum, everyone? What is the meaning of injuria sine damnum? Injuria means injury. Sine means without. Damnum means damage. Now remember one thing, the most essential element for tort is damage plus injury. Correct? But if there is only damage and no injury, it might not always be a tort. On the other hand, whenever there is injury without damage, then what happens? Do you know the case of the name of the case law? How many of you know the name of the case law? Did you all note the name of the case law, Gloucester Grammar School? Over here, there is a case law. Fast, everyone tell me what is the name of the case law. How many of you remember the case law? Yes, fast. How many of you know the name of the case law that is given in injury without damage? Injury without damage. Name of the case law. The name of the case law is Ashby versus White. Can anyone tell me what had happened in this case law? There was a boy who wanted to go for vote. He went for voting, and there was a police officer who was standing there. So there is a boy, he goes for voting, okay? And when he goes for voting, there is a police officer. Police officer tells him that, sorry my dear, I will not let you go and vote. What is the police officer trying to tell him? That, sorry my dear, I will not let you vote, okay? So this police officer does not let him vote because, no, it is not actually, it is Ashby versus White, okay? The police officer says that the party to whom you will be voting is any which way is going to win. So how does it matter if you vote or not? The boy got furious, the boy sued the police officer. When the matter went in the court, the court said that, yes, there is no damage done to the boy because of you, but you have caused injury to the boy. Sir, what is the meaning of injury over here? Everyone, my dear students, the meaning of injury or injuria is nothing but infringement of right. What is the meaning of injuria over here? Infringement of right. So the boy's rights were infringed. That is the reason why he can sue other person for tort. So in law of tort, what is important? Damage or injury. Certain damages are tort, but all damages are not tort. But if there is only injury, there is no damage, then also it will be a case of tort. And injuria without damage, the case law is Ashby versus White. I hope all the students have understood this concept. I hope all the students have understood these concepts. And I hope that you all have liked the video. Yes, no. You all will remember one thing, that exams will come and go, but knowledge should remain constant and it should go on forever with us. Correct? Is there any doubt to any student? No doubt, no question, no query? No doubt, no question, no query? Very good. So everyone, wrongs are of two types. Moral wrongs are not actionable. If there is a moral wrong, it is not actionable. Legal wrongs are actionable. Legal wrongs are civil and criminal wrongs. Civil wrong contains tort, breach of contract, breach of trust, breach of equitable obligations. But over here, we will be focusing only on tort. Now, general condition of tort. If there is a tort, you want to prove that a tort has happened with you. CS Executive exam question, general conditions of liability of tort. Number 1, there should be a wrongful act or omission of the defendant. Something wrong the defendant has done. Defendant means the person who defends himself in the court. Next, the wrongful act caused legal damage to me. So, your wrongful act is causing legal damage to me and I should have a legal remedy for it. If there is no legal remedy for it, then it is not a tort. I hope this is clear. So, condition for tort. Wrongful act of defendant. Wrongful act should cause legal damage and it should give legal remedy. Yes, no? Yes. I hope this is crystal clear to all the students. I have expressly, very beautifully already explained damnum sine injuria, injuria sine damnum. You know the meaning of injury. Injury over here does not mean that injury. Injury over here means infringement of right. We have understood the case law. We have understood all of these things. Last but not the least, legal remedy. Okay. Now, to constitute a tort, the wrongful act must come under the law. The main remedy for tort is an action for unliquidated damages. Unliquidated damages means what? Which damages which are not prefixed. Liquidated damages are damages which are prefixed by law. Correct? I hope this is crystal clear. So, sir, you have committed tort with me. Now, what right will I have? You can file for injunction. Okay. Or specific restitution can be claimed. You can claim inaction for detention of chattel. Self-help is also a remedy. We see this in the last part of this chapter. So let us not focus onto this. The last part is remedies for tort. We all know that there will be judicial remedy and extrajudicial remedy. Now, let us come down to mens rea. Everyone, the meaning of mens rea is guilty mind. What is the meaning of mens rea? Mens rea means guilty mind. What is the meaning of mens rea? Mens rea means guilty mind. So, if you want to sue me for tort, should I have a guilty mind? Is guilty mind required for tort? What is your answer? Fast. Yes or no? Fast. If I have committed tort, do you have to prove that I had mens rea? Yes or no? Fast. Reply first, everyone. Please, fast. Reply. Yes, first. To hold me accountable for tort is proving guilty mind important? The answer is no. Guilty mind is not important. I am playing cricket. I hit a ball. The ball hits your car. Did I have anything in my mind? What did I have a guilty mind? No. So everyone, guilty mind is not required for tort. But the general principle is actus non facitium nisi mens et tria. What is the meaning of this? The act itself creates no guilt in the absence of guilty mind. It does not mean that for law of torts, the act must be done with an evil motive. But an act done without wrongful intention or negligence is more than enough to catch me by my collar and sue me for a tort. Is this clear? Is this clear? I hope this is crystal clear to everyone. Now, mens rea can be interpreted in two ways. Fault, state of mind when relevant. Next is liability without fault. So, everyone, assault, battery, false imprisonment, you have guilty mind. You have guilty mind over here. You have mens rea in these cases, okay? But liability without fault means the mental state is irrelevant, but still there will be liability on me. There will be still liability on me. I hope this is crystal clear to everyone. So, for a tort to happen, is mens rea important? The answer is no, mens rea is not important. There is a Latin maxim called as actus non facitium nisi mens et rea, which means that for the act that has happened must be done with an evil motive. And if you do an act without evil motive, then it might not be a crime, but it can be a tort. Yes or no? Yes. Now, let us talk about strict and absolute liability. Strict and absolute liability falls. There are certain cases which fall under these categories. Number one, liability for inevitable accident. Number two, liability for inevitable mistake, and liability for wrongs committed by others. Vicarious liability for wrong committed by other. Now, first things first. Sir, in some torts, I will be held liable even though the harm to the plaintiff occurred without my negligence or intention. I was not negligent. I did not have bad intention. Still, the wrong was committed with the defendant, with the plaintiff. I did not do it intentionally. I did not do it purposefully. Still, wrong has happened. Even then, I will be held liable. This is the concept of strict or absolute liability. This is the concept of strict and absolute liability. In simple words, defendant is liable without fault. What are the cases where the defendant will be held liable? Number one, liability for inevitable accident. Everyone, if you bring dangerous material with you, if it escapes, it is going to cause harm, you are liable. It is inevitable accident. If I am carrying a snake in my bag and the bag is kept here, the snake will go out and it is going to cause some kind of accident and it is inevitable. Next is liability for inevitable mistake. If you interfere with property or reputation of another, then you are liable. Last but not the least, vicarious liability for wrong committed by other. Vicarious liability for wrong committed by other. Everyone, in this case, the act was done by my servant, but I was held liable. The act was done by a third party, but I was held liable. Is this clear? Master will be liable for the acts of the servant. Now, everyone, please reply ASAP. Tell me, do you know the case of Ryland versus Fletcher? Do you know the case of Ryland versus Fletcher? There was a guy who had a piece of land. He wanted to build a water tank. Now, he was not knowing that below the ground, there were old mine shafts. He was not aware about those mine shafts. But he called some engineer. He called some third-party contractors to see the site and construct the water tank. Now, the engineers constructed the water tanker, and once the water was filled in it, the mud, it collapsed and the tank fell down, and there was a neighbor in whose field all the water went away. The person had coal mines. So, the coal mines were flooded with water. Now, the person whose coal mines were flooded with water sued the person who built the water tank. Now the question is, the person who built the water tank said that it is not my mistake. I did not intend to do it. It happened. It was out of my control. It was not in my control. I will not be liable. And if you want to hold someone accountable, hold these engineers accountable. Now you all the students tell me, will the engineers be held liable? Will the engineers be held liable? Yes or no? What a provision will you use? Ryland versus Fletcher can be asked in examination. This is your Captain America, Shubham Joshi speaking. Please answer fast. Yes. Yes. Do you think that the engineer should be held accountable? The answer is no. The answer is no. The engineers will not be held accountable. The answer is no. The engineers will not be held accountable. Why? Because in case of strict or absolute liability, the person who brings or collects any dangerous substance on his land, and if that thing escapes, then that person himself will be insurer to loss that is happening to other people. I hope this is clear to everyone. So everyone, there was a mill owner from where it happened. Okay, so there was a judge called as Justice Blackburn. Justice Blackburn said that look at this judgment. You are supposed to write this judgment in the exam if they ask a question. See, what have they asked? If a person for his own purpose brings on his land and collects and keeps anything likely to do mischief. I brought something on my land which is likely to cause mischief, and if that thing escapes, then I have brought it at my own risk, and he is prima facie answerable to the damage which is natural consequence of its escape. Now, there was another case in which this concept was fortified, and the case law's name is Reed versus Lyons. The name of the case law is Reed versus Lyons, in which the judge said that there should be two conditions, and if these two conditions are there, then only you will hold the other person liable for absolute or strict liability. So in order to hold a person liable for absolute or strict liability, we need to prove two things. Thing number one, escape from the control and non-natural use of land. If only escape has happened but it was not a non-natural use, then I will not be liable. I am doing the use of land in a non-natural way. I am using the land in a non-natural way, but it has not escaped, then I will not be held liable. To hold me accountable under strict liability, you need to prove both these cases. So everyone, in Rylands versus Fletcher case, Justice Blackburn said that if you bring something dangerous on your land, it escapes and causes mischief, then you are liable, answerable for all the loss prima facie. But in the case law of Reed versus Lyons, it was held that you need to prove two things. First, escape should be there, and second, non-natural use should be there. If escape has happened but the use was natural, I will not be held liable. If there is non-natural use but nothing is escaping, then I will not be held liable. I hope this is crystal clear to everyone. Again, put fire and be confident about yourself that you will clear this exam in first attempt. Yes or no? Is the concept clear to you all? Are all the topics and concepts clear to you? Fast! Reply fast. Yes. Is this crystal clear to all the students who are watching the session? Yes. Now, exception to the rule of strict liability, CS Executive exam question. CS Executive exam question. They will ask you this question for 4 to 6 marks. Exception to the rule of strict liability, your institute's favorite question. Exception to the rule of strict liability. Number one, damage due to natural use of land. If the damage has happened because of natural use of land, then you will not hold me accountable. If the damage is because of natural use of land, you will not hold me accountable. I repeat again, if the damage is due to natural use of land, I will not be liable. Okay, what is the natural use of land? Do you know? People put fireplace in their house. If you go in foreign countries, people, because the climate is very cold, you might have seen in movies that there is a chimney in the house from where Santa Claus falls in, correct? And they burn wood so that the house is warm. If you have made a fireplace in your house and there is a fire in your house, and you burn, that fire burns the neighboring houses as well, then I will not be held liable. If there is a gas cylinder in my house, it blasts, I will not be held liable because I was doing natural use of land. Is this clear? Is this crystal clear? Next is consent of the plaintiff. If I have constructed this water reservoir by taking permission from you, I took permission from you, and then I constructed this water reservoir, and the water reservoir falls down, and your property is also damaged, you will not hold me accountable. Everyone, CS Executive exam question, this is important. Exception to the rule of strict liability. Number one, damage due to natural use of land, I will not be held accountable. Consent of the plaintiff. If I construct anything by taking your permission, if I bring something dangerous by taking your permission, then I will not be liable. I hope this is crystal clear to all of you. They have given an example: A and B living in the same housing complex gives permission to install water pipes. One of the water pipe leaks, thereby causing leakage problem. Neither A nor B will seek for damages under law of torts. Wow, very good. Now, everyone, Box versus Jupe case law, act of third party. Everyone, if the harm is caused because a stranger has caused damage to defendant, then because of, now see, there is a stranger, because of him I am suffering, you are filing a case on me. There is a case law of Box versus Jupe. There was a water pipeline, pipeline, okay, it was blocked by some third person. The pipe burst and the water was overflowing from that drain and it damaged your fields. Will you hold me accountable? No. Why? Because this was done by third party. It was not me. But I will be held liable if I knew that the third party is going to cause damage. I repeat again, I will be held liable if I knew that the third party is going to cause damage. Failure on part to avoid such damage will make him liable. Who? The defendant will be liable. But if not, if I was not knowing that a third party is going to cause the damage, then I will not be held accountable. Now comes statutory authority. See, public bodies are having the work of storing water, supplying gas, electricity, okay, and they are given immunity by law. But they have to take reasonable care. Green versus Shalza Waterworks case law has been asked in CS Executive exam. Everyone, there was a company whose work was to maintain continuous supply of water, but a pipe broke and it damaged the plaintiff's premises with flood. Okay, now it was held that the company is not liable because it was performing a statutory duty. What is the meaning of statutory duty? It was performing a legal duty. Is this clear? My favorite, act of God. I was storing dangerous chemical, but because of earthquake, because of flood and tsunami, the chemicals broke down, it damaged everything. I will not be held responsible. If escape is caused through natural causes without human intervention, no human foresight can provide against, and of which human prudence is not bound to recognize the possibility, then I can defend myself by saying act of God. Now this is my favorite, escape due to plaintiff's own default. Now there was a dangerous chemical. This is a dangerous chemical which is stored in my building. Okay, this is a thief. He comes in my building to, obviously, to rob my building, to steal something from my building. When he comes there, he sees that nothing is there. Now he decides that he will run away from there. Okay, but he arranged the containers one on the another for the purpose of reaching at one place. So what did he do? He kept one container on the another to climb upstairs. Okay, now while he was climbing, he fell and the chemical in the container spilled on him. Can he claim damage? No. The fault was your own. You are burning your hand because of the chemical. You have contracted with some disease because of the chemical. I will not be held liable. I will not be held accountable. I hope this is crystal clear to everyone. Now, let us talk about India. MC Mehta versus Union of India. I'll put a star mark over here. How many of you know this case law? Please write me in the comment section fast. We don't have a lot of time. In next 20 minutes, we are completing TOT and I'll be starting off with Indian Constitution and I'll be taking important topics of Indian Constitution for you all. ASAP reply fast, everyone, fast. Yes. How many of you know the case law of MC Mehta versus Union of India and what is the applicability of rule of Ryland versus Fletcher in India? Oleum gas leak had happened. Very good. Oleum gas had leaked. There was a company called as Shri Ram Foods. There was a company by the name of Shri Ram Foods. Now listen carefully. I will summarize this entire point for you all. A lot of students are watching the session. They are not responding. I will summarize this section for you all. In India, see, Ryland versus Fletcher case, judge said that someone brings dangerous thing on his land. If that thing escapes, he himself will be liable. Second thing, Reed versus Lyon, there were two conditions. One, there should be non-natural use of land. Number two, the thing should escape, correct? In India, after this case, the Supreme Court held that if any person or any organization is dealing in inherently dangerous nature of goods, then no matter how good care they take, if it escapes, they will be answerable. Which means in India, you don't have to prove these two conditions. In India, you don't have to prove these conditions. I hope this is clear. This is the summary of this entire thing. This is the summary of this entire thing. I hope this is crystal clear to all the students who are watching this session. Okay, concept is clear. No doubt, no question, no query. Pinky promise, everything is clear to you all. Now let us talk about vicarious liability. Let us talk about vicarious liability. So in absolute liability, no matter your intention was good or bad, you are negligent or not negligent, if damage has happened, you will be liable. That is the principle of absolute or strict liability. In vicarious liability, the tort is done by some other person, but I will be held liable. So the wrong is committed by someone else, but I will be held liable. In vicarious liability, a master is liable for the acts or torts of his servant, okay, or tort of his agent and partners, okay. This is called as vicarious liability in tort. This is called as vicarious liability in tort. Principle of liability, everyone, you can be held liable in respect of wrongful acts or omission of another in ways given below: by ratification, by relation, by abatement. By ratification means what? By ratification means what? You have given approval to do some act in a different way. Okay. Number two, relation. Because he's your servant, he's working for you, he's your partner, he's your agent, you will be held liable for the wrongs committed by him. And by abatement means what? I am forcing you, not directly, indirectly, to do that act. Okay. Now, let us understand elements of vicarious liability. Number one, there must be an existing relationship between master and servant. Servant should commit some tortious act, and the tortious act must be done during the course of employment. During the course of employment. If the act is done after the course of employment, the master will not be liable. The first point is principal agent relationship, types of vicarious liability. In this, there is a case law by the name of Lloyd versus Gray Smith. Now, there was a clerk of in the firm of solicitors. What he did was, in ordinary course of business, he committed a fraud against a lady client. He took her signatures and transferred her property to him. Now, he did so without the knowledge of his principal. Now, the lady sued the firm of solicitors. Are the firm of solicitors liable? Obviously, the firm of solicitors will be liable, because kui fasit par alam fasit par se. I repeat again. Kui fasit par alam fasit par se. He who does things through others is he himself doing it. He who acts through another is acting himself. I hope this is crystal clear to all the lovely students. Next is the term partners. Everyone. Partners are agents and principals of each other, correct? So if one partner does something, all the other partners will be held liable, even if the other partner was not aware of the actions of the other party. So there was a case law of Hamlin versus Houston. One of the two partners gave bribe to the plaintiff's clerk and induced him to give the secrets relating to his employer's business. It was held that both the partners are liable for the tort committed by only one of them. Koi fasit par alam fasit par se. Then comes master and servant, and here the authority is because of the relation. I have a relation with you. You are my servant, I am your master. Now, everyone, master is liable for tort committed by his servant, while the servant is acting in the course of employment. Correct? The servant, of course, is also liable. Their liability is joint and several. See, my servant did something. He broke your imported vase. Now, I will be held liable for it. I have to pay, but I can recover that money from him. So, our liability is joint and several. You will catch my collar. You will catch me. You will hold me accountable. You will not hold my servant accountable. Correct? But I can recover that money from my servant. In such cases, liability of person is independent of his wrongful intention or negligence. See, my servant was negligent. He kept a hammer on the window. The hammer fell down. My servant will be liable, but I will also be equally liable because I was not taking proper care. Next is liability is joint as well as several. In case of vicarious liability, the liability has arisen because of the relationship between the principal and the wrongdoer. But in case of absolute liability or strict liability, the liability arises because of the wrong itself. The liability arises because of the wrong itself. I hope this is crystal clear. Now, there are two Latin maxims to hold the master liable. One is respondeat superior, which means let the principal be liable. Another one is cui facit per alam facit per se. He who does things through others is he himself doing it. I hope this is crystal clear to all the dear cute students. Doubt, question, query? No doubt, no question, no query. Concept is crystal clear. Very good. Now, master is liable even though servant acted against the instructions of the master. So even if the servant is acting against my instructions, still I will be liable for the benefit of his master so long as servant acted in the course of employment. If he did something for me only but not in the right way, even though I had told him not to do it in this way, still I will be held liable. I hope this is crystal clear to everyone. Now comes the main part, employer and independent contractor. Now everyone tell me, if this is my company, this is my company, this is Shubham Joshi, this is Shubham Joshi, this is Shubham Joshi. Oh, oops, I forgot to write Professor Shubham Joshi. Now, in my company, I hire security guards. I hire security guards. I don't hire them directly. I go to a consultancy firm. They send 2 security guards to for my company. If they do something, will I be held liable? Will I be held liable? How do you understand who is your employee and who is your independent contractor? What is the true test of it? Everyone, the true test of understanding who is your employee and who is your independent contractor is the control of the work. If you are controlling what work they do, they are your employee and you will be liable. But if you are not controlling their work, then that person will be called as independent contractor. Then that person will be called as independent contractor. I hope this is crystal clear to everyone. So everyone, remember one thing. If there is employer and independent contractor, then employer is not liable for acts of independent contractor. The employer is not liable for acts of independent contractor. But there are certain cases where employer will be liable for acts of independent contractor. But first things first, how do you understand who is an employer independent contractor? There is only one thing, and that is, if the employer has control on the performance of services, then he is your employee. And if there is no control on your services, on the performance of the work, then that person is your independent contractor. I hope this is crystal clear to everyone. I hope this is crystal clear to everyone. Now tell me one thing, there are certain cases where employer will be liable for acts of independent contractor. What are those cases? Number 1, where I have authorized you to commit tort. You are independent contractor, but I am authorizing you to commit tort. Strict liability case. Give me example fast. Give me example fast. Strict liability case. Independent contractor. We just saw Rylands versus Fletcher case, correct? We saw Ryland versus Fletcher case. In Ryland versus Fletcher case, did we not see that the person who built water reservoir had hired independent contractor? But since it is case of strict liability, if you bring something dangerous, it escapes, you will be liable no matter who did it, correct? Last is negligence of independent contractor. Negligence of independent contractor is also called as collateral negligence. Now, what is the meaning of this? See, I told you the example, right? If I have hired independent contractor to build a window casement for me. So this is my building. In my building, there is a window on which an independent contractor is working. I have hired an independent contractor to fix wooden plank over here, and that independent contractor has kept a hammer right on the edge. And with the wind, one of the wood plank moves and it pushes the hammer, it falls down on a person who is walking on the street. Who will be held liable? I will be held liable. Why? Even though he is independent contractor, because even I myself was negligent, right? I should have made sure that he doesn't do that thing. Yes or no? Yes or no? Now, employer is not liable for acts of independent contractor. Why? Because I have taken proper care for appointing the independent contractor. Still he does something wrong, I will be not held liable. The case is Philips versus Britannia Hygienic Laundry Company. I gave my truck lorry for repairing to an independent contractor. Okay. Now the truck's brake failed and it caused damage to third person. Will I be held liable? No. Why? Because I had chosen the perfect company to fix the work. I will not be held liable. Now, liability for acts of servants and employees. Everyone. Employer will be liable wherever his servant commits a tort in course of his employment. Okay. Sir, what do you mean by act committed in the course of employment? If it is done authorized by the employer, you did something and I authorized you to do it, or I told you to do a wrongful and unauthorized mode of doing the act. Okay, then I will be held liable. Okay, now Century Insurance Company versus Northern Ireland Road Transport Board. How many of you remember this case law of cigarette? How many of you remember the case law of cigarette? The driver of petrol lorry, while transferring petrol from lorry to an underground tank, at a garage struck a match in order to light a cigarette. And then he threw the lit match on the floor. Explosion and fire ensued. House of Lord held the employees are liable for the damage caused, for he did the act in the course of carrying out the task of delivering the petrol. It was an unauthorized way of doing what he was employed to do. I hope this is crystal clear to everyone. And there is no doubt, no question, no query to any of these students. Okay. Now, vicarious liability of state, position in England, until they did not bring Crown Proceeding Act, the king was not liable. Position in India, you should know this, that we can hold government accountable for acts committed by government servants. But for which act will we sue the government? Non-sovereign functions you can hold the government liable. For sovereign functions the government will not be held responsible. I hope this is crystal clear to everyone. So position in India, you can hold the government of India accountable by using the same principle of respondeat superior, and the reason for that is tell me the reason for that. Only when the person has done something non-sovereign. Okay. But if it is a sovereign function, then you cannot sue the government. Is there any doubt to any student? Is there any doubt to any student? Is there any doubt to any student? No doubt, no question, no query. No doubt, no question, no query. Now, I'll not be discussing the case law because I'm assuming that you have read all the case laws. These case laws are important, okay? Kasturi Lal versus State of UP and State of Rajasthan versus Vidyavati. These case laws are important. Let us go directly to the next concept of torts or wrongs to personal safety and freedom. Okay, till here, did you all understand everything? And I hope all the concepts are crystal clear to all the dear students. Now, let us understand the different types of wrong. What is the meaning of battery? Everyone, if I am angry and if I keep my hand, if you keep your hand, sorry, if the other person is angry and if he keeps his angry hand on me, it is battery. So everyone, direct application of force to individual without his consent or lawful justification is wrong of battery. See, with my consent, yes. With lawful justification, yes. But without my consent and without lawful justification, no. Use of force can be trivial. It may be without plaintiff's consent and without lawful justification. Even if the force is not causing any harm, the wrong of tort is committed. So even if you touch someone in anger, you have committed the act of battery. Even if you touch someone in anger, you have committed the act of battery. Now, defense. This principle has been implied in Indian decision in the case of Sitaram versus Jaswant Singh. It was held that an occupier is entitled to expel a trespasser and if necessary even forcibly remove from his premises. But the force should be reasonable and not greater than necessary. Okay, quite disproportionate to evil to be prevented. I hope this is crystal clear to everyone. So everyone, if I touch you in anger, but I have lawful justification, you trespassed on my property, that is the reason I got angry on you, I tried to push you. The force that I used, pushing, beating you, whatever force that I use, if it is reasonable, then it is not a tort. But if I'm using unreasonable force to remove you, even if you have done something wrong, but the unreasonable force will not give me the immunity. I hope this is clear. Now, tell me what happens first. Is battery that is going to happen first, or will there be assault that happens first? What will happen first? Assault or battery? What happens first? Fast. Reply fast. We have to go and start with Constitution of India. Fast. What happens first? Assault or battery? Tell me fast. What happens first? Assault or battery? The chapter is about to get over. In next 10 minutes, the chapter will get over. And then for the next hour, we'll be focusing on Indian Constitution. Yes. Yes. Assault or battery. What is the meaning of assault? The meaning of assault is very simple, very clear, that if I make you feel that I will be committing the act of battery, if I will be committing the act of battery, then it is assault, which means first there is assault and then there is battery. So if I'm in anger and if I'm doing this, now you're gone. This is assault. Because when I do this, I am trying to show that I will be committing battery. So my dear students, you are wrong. First there is assault and then there is battery. First there is assault and then there is battery. I hope this is clear. Everyone, assault is an act of defendant which causes the plaintiff to apprehend a contact with his person. So when a defendant by his act creates an apprehension in the mind of plaintiff that he is going to commit battery, the tort of assault is committed. Everyone, assault means now you are gone. Now you are gone. If I do this, is assault. Now when you are standing in front of me and I'm doing this, now you are gone. Now we'll see what I do. you will be feeling in your mind that I will be committing battery. The thought that comes to your mind is that I will be committing battery. Is this clear? So assault happens first, then battery happens. And in all the assault, there need not be battery, but in all the battery, there is assault. Write down on top margin in your notebook, in all assault, there is battery, but in all, in all assault, there need not be battery, but in all battery, there is assault. I hope your doubt is clear, everyone. I hope your doubt is clear, everyone. I hope your doubt is clear, everyone. In all assault, there need not be battery, but in all battery, there is assault. So if I do this, it is not necessary that I will touch you. But if I've touched you, which means there was an assault first. But there is only one case where there is battery without assault. One case where there is battery without assault. There is only one case where there is battery without assault, and that case is which is that case? When you hit someone from behind. When you hit someone from behind. One case where there is battery without assault, when you hit someone from behind. Is this clear? Is this clear? Remember this. They can ask you such things in exam. Bodily harm. What is the meaning of bodily harm? Everyone. Bodily harm means calculated way of causing physical harm to the plaintiff. Okay. I know that whatever I do is going to cause physical harm. It is called as bodily harm. Okay. False imprisonment. False imprisonment means what? Total restraint for some period, however short, on liberty of another without sufficient lawful justification. I am sitting and taking a lecture in this room. Someone locks the door from outside. Total restraint for some period, however short. You have done false imprisonment. You have taken my liberty. But if you are doing that, you should have lawful justification. If not, then you have committed the tort of false imprisonment. Is this clear? It means if you are unauthorizedly restraining a person's body, unauthorizedly stopping a person from going. What happens in false imprisonment is that a person is confined within certain limits so that he cannot move about, and so his personal liberty is infringed. Okay. In a serious violation of person's right and liberty, whether being confined within the four walls or by being prevented from leaving a place where he is. You will not go out until my daughter gets married. False imprisonment. If you come out of your house today, I'll break your legs. Is this clear? I hope this is crystal clear to everyone. Now put a star mark and write 4 marks exam question. 4 marks exam question, malicious prosecution. Everyone, what is the meaning of malicious prosecution? You filed a case against me without any intention. You just wanted to harm my reputation. Usually these cases are called, these are criminal cases. So malicious prosecution means you have instigated a judicial proceeding against me without reasonable or probable cause. Okay, which terminate in favor of other and which results in damage to his reputation. It has damaged my reputation, personal freedom or property. Essential elements for malicious prosecution. Please note this. This is very important. Number 1, prosecution of plaintiff by defendant. Number 2, want of reasonable and probable cause. Number 3, defendant acted maliciously. He did not have any motive. He did not want any justice. Because of this, I suffered damages, and now the prosecution has terminated in favor of plaintiff. I will sue you. Is this clear? See, look at the example. A had a grudge against B. A falsely implicated B for theft. The prosecution was launched against the plaintiff on the basis of false report made by B. The court acquitted A after finding that the allegation was false. Now, after acquittal, A filed a suit for recovery of damage for his malicious prosecution. I hope this is crystal clear. So the judgment will be in my favor. It was proved that he just filed a case against me. Now, once the judgment is out, I will file a case against you for malicious prosecution. These 5 conditions are of utmost importance. I hope you have understood this. Now, what is the meaning of nervous shock? Nervous shock. what is the meaning of nervous shock. This is a new type of thing which has been added in law of torts. Now, if you tell some news to someone, now see, nervous shock does not mean that you scare someone. But if you scare someone by giving some bad news or you're doing some prank, and because of which the person has got some kind of emotional disturbance, fear or sorrow, or it has caused some injury or illness, then and only then it will be treated as nervous shock. A negligently drove the carriage onto railway tracks while the train was on the verge of crossing. Okay, your lady is sitting in my carriage. I took the carriage. Where did I take it? Where did I take the carriage? I took it on railway crossing. Okay. Now, by this accident, there was a lady received a nervous shock which leads to bad impact on her health. A would be liable for damages for the consequences of nervous shock. I hope this is clear. Now, everyone, defamation is of two types. What are the two types of defamation? One is libel. Another one is slander. Now, fast tell me which is permanent and which is temporary. Which type of defamation is permanent and which type of defamation is temporary? Everyone, remember one thing. Libel means something in permanent form. Slander means said by the way. Okay. It is temporary in nature. Okay. And on defamation, which is libel, usually we can take criminal action. I hope this is clear to you all. Next is negligence. Negligence means inadvertence or carelessness. Now, negligence means a situation where a person might be innocent but has failed to act in reasonable manner. You are innocent, but you failed to act in reasonable manner. Negligence has become an independent tort with the changes in technology and regulatory environment. Okay. Now, please focus on this definition. Okay. Negligence as a tort is the breach of legal duty to take care which results in damage. It was your legal duty. You did not take care of your legal duty. Because of that, the other person had some damages. You will be liable for the tort of negligence. Is this clear? Consumer Protection Act has also been developed and provides for unliquidated damages in cases of negligence. Okay. I hope this is crystal clear to all of you. Now, let us go to the next topic, remedies in tort, judicial and extrajudicial remedies. Till here, does any student have any kind of doubt, question, query? Now, judicial remedy and extrajudicial remedy. Judicial remedy means what? I will go to court and seek remedy. Damages, injunction, specific restitution of property. Extrajudicial remedy, self-defense, prevention of trespass, re-entry on land and recapture of goods. Everyone, damages. Now, judicial remedy means damages. Now, the plaintiff has right and his right is violated by defendant. The court will grant plaintiff damages, which are compensation for such infringement. What is the meaning of this? I was playing cricket. While playing cricket, I hit the ball so hard that it broke someone's window, or I hit the ball so hard that it hit someone on their leg and their leg was fractured or there was a crack. I have to make compensation to them. I hope this is clear. Damages are primary judicial remedy served in tort. Injunction means what? What is the meaning of injunction? Online students, reply fast. Injunction means stay order. Okay. Now, you had promised that you will not do something. Now you are doing the same thing. I will put injunction on you, stay order on you. Is this clear? For example, you have a dog. There is no compound between your and my garden. Your dog is very ferocious in nature. I feel that the dog can attack me or my property. What I do is, I go to the court, you're not listening, I'll put an injunction that you cannot use your dog in the property. I know the example is very odd, but it's fine. I hope you have understood this. Next is specific restitution of property. Now, this means restitution is the process of returning the property to its rightful owner. A person is entitled to restitution of his property when it is been unfairly taken away from him. Wrong disposition of certain property invokes this remedy. For example, plaintiff may bring an action for restitution in specific relief act. Now, they have not given anything in detail, but I hope you have understood that if my property is wrongfully taken from me, I'll go to the court and take back the property. I hope this is clear. Now comes the most important. I will write here exam question again. Extrajudicial remedy. First is self-defense. If I have to use force, I will use reasonable force to protect myself. Okay. Prevention of trespass. If you have come on my land if you have come on my land without my permission, I will use reasonable force to prevent the trespasser from entering on my land or to remove you. The force should be reasonable. Re-entry on land. If someone took my property, I have the right to remove that person from my property. X trespasses into B's property, his home. B has the right to use reasonable force to remove him from the property and re-enter himself. Recapture of goods. Everyone, imagine I see a bike on road. That bike belongs to me. It was stolen 6 months ago. Now it is there in your compound. I will open the gate, take the bike and go away. I have recaptured the goods. I have recaptured the goods. I hope this is also very clear. Now, abatement of nuisance. What is the meaning of abatement of nuisance? Abatement of nuisance means I think right now there is no damage that is going to happen, but certain things can cause damage or harm to me. So the occupier of land may lawfully abate, terminate by his own act. See, there are trees which are coming from your house to my house. I feel I have small children in my house. They play in the garden. What if someone stumbles and falls on the tree? What if it hits them? What if it goes through their body? What if someone dies? So in order to prevent that accident, I will cut the tree. But before doing that, I should give you notice. Whatever method I use to cut the tree, it should be the least mischievous method, and I have to avoid unnecessary damage. I hope this is crystal clear to everyone. Distress damage pheasant means seize cattle wrongfully moves to D's property and spoil his crops. You had some sheep and goats and cows. They came to my farm. They damaged the crops that I have. Now I have kept the cows and cattle with me until you pay the money to me. I have kept them with me until you make the payment to me. You make the payment, take your cow, take your goats away. Distress damage pheasant. Occupier may lawfully seize any cattle or any chattel which are unlawfully on his land doing damage there and detain them until compensation is paid for the damage. I hope this is crystal clear to all of you. With this, we have completed the topic of law of torts. I hope there is no doubt to all the students. Yes. Easy. Doubt, question, query, everyone. Doubt, question, query. Yes, everyone, doubt, question, query. Any doubt, any question, any query, feel free to ask. Yes. Feel free to ask any doubt, question, or query that you have. Yes. No doubt, no question, no query. Let us start with Constitution of India. Let us go and start the topic of Constitution of India. I will specifically tell you what all has been asked in exam a lot of times. You have to focus on those topics first. Okay. Easy. Yes. Yes. Case based study questions are asked. Yes. They can ask you case study based questions. No doubt in that. They can ask you case study based questions. 100% they can ask case study based questions. And law of torts as well. Practical questions can be asked, but they will be very simple and easy. Okay. Now let us understand Constitution of India. Let us go to the topic of fundamental rights. Okay. Fundamental rights, part 3 of Constitution. Article 14 to 18, right to equality. 32, constitutional remedies, right to freedom, right against exploitation, culture and education rights, right to freedom of religion. Okay. Now let us begin. Let us understand everything one by one. Okay. Let us begin and understand everything one by one. Okay. Now, the first definition that can be asked in exam is the definition of the state. There was a case law. Please tell me the name of the case law. I am very bad at it. I hope it is Ajay Hasia versus Khalid Mujib. Do you know the case law? How many of you know the case law? Please, fast. You should have that energy in you. You should be full of that energy in you. You should have that thing inside you. Said, I want to clear this exam no matter what. I will clear this exam. Yes. Ajay Hasia versus Khalid Mujib. How many of you know the case law? CS Executive exam question asked multiple times. Multiple times. Yes. How many of you know the case law? Ajay Hasia versus Khalid Mujib. Reply fast. Respond fast. Respond fast. Respond fast. Yes. Very good. Such a strong response you have. Yes, no. Is there a yes? Is there a no? Definition of state. Very good. Definition of state. Definition of state is given in article number 12. Article number 12 talks about the definition of state. Now, According to Article 12, this is the definition. According to Article 12, this is the definition. Government and Parliament of India is state. Government legislature of state is also state. So government and parliament is state. Government legislature of state is also state. And all local and other authorities within territory of India or under control of government of India are state. This is a very simple definition. But there was a case by the name of Ajay Hasia versus Khalid Muji. In this case law, our Honorable Supreme Court gave a proper definition of state. This case law is extremely important. This is exam question that define the term state as per Ajay Hasia versus Khalid Muji. This case law was in the year 1981, where Supreme Court of India gave a proper definition of the state. If the company's entire share capital is held by government, then that company will be treated as state. Okay, if the entire corporate share capital of the company is held by government, it will be treated as state. Number 2, financial assistance to meet almost the entire expenditure is provided by the government, then that organization will have government character and it will be also called as state. Are the 2 points clear? Fast, reply fast. Are the 2 points clear? Ajay Hasia versus Khalid Muji. What is the meaning of state? Article 12 says that government and parliament is state, and state legislature of the states is also state. Any local or other authority within the territory of India or under the control of government of India is also state. There was a case law in 1981 where the name of the case law was Ajay Hasia versus Khalid Muji, where Supreme Court defined, explained, elaborated the concept of state. Number 1, share capital entire is held by government, state. Any organization whose almost all the expense is met by government, state. Next, the corporation enjoys monopoly status and the right is protected by the state, that corporation will also be treated as state. Next comes there is a deep control of the state in any corporation. The company is controlled by state agency or corporation. The corporation is controlled by government, then that company will also be treated as state. Then the functions of the company are of public importance and they are closely related to government functions, then also that organization will be treated as state. Last but not the least, if a department of government is transferred to a company, if a government department is transferred to a company, then that department which is transferred to the company will also be treated as state. I hope this is crystal clear. They will ask this exam for 7 marks in the exam. You first define the term state and then write these 6 points. I hope this is crystal clear to all the students. I will take a quick recap of all the points so that you will also remember and highlight all these points. Number one, entire share capital is held by government, state. To meet all the financial expenses, financial assistance is provided by the state. That company will be called as state. The company enjoys monopoly status and that status is protected by the government, that company will be called as state. Deep control is there of the government, then that company will be called as state. The company has very strong function of public importance, that company will be treated as state. The department of government is transferred to a corporation, then that department will also be treated as state. I hope this is crystal clear to all the students who are sitting and watching the session. No doubt, no question, no query. Now let us talk about justifiability of fundamental rights. Article number 13 is divided into 2 parts. 13.1, 13.2. Okay, 13.1 says that existing laws which are inconsistent with fundamental rights will be removed. What does Article 13.1 say? Existing laws which are inconsistent with fundamental rights will be removed. Article 13.2 says that in future, if any law is made, they will not be inconsistent with fundamental rights. Full stop. Our constitution has given us fundamental rights, and Article 13 says that any existing law which is taking away your fundamental right will be removed. Existing law as in on the date of 1950, 26th Jan, any law which was made before this, if it is taking your fundamental right, it will be removed. And in future also, if you make any law, it will not take away your fundamental rights. I hope this is crystal clear in existing and future law. I hope you have understood this. So Article 13 is divided into 2 parts, 13.1, 13.2. Existing law should not be against fundamental rights. Future laws should not be against fundamental rights. I hope this is clear to you all. This page is clear to you all. Now let us talk about doctrine of severability, 4-mark exam question. Doctrine of eclipse, 4-mark exam question. Your institute's next favorite question after the definition of state. Article 13 very rarely asked, but this can be asked in examination. Everyone, any law which was there before the making of constitution, any law which was there before the constitution commenced, if that law or the some part of the law is going against the fundamental right, not the entire law, some part of it, not the entire law, some part of it is taking away our fundamental rights, then only that part will be removed. But before removing that part, we must make sure that it does not change the language of law. I hope this is clear. So only that part of the law will be declared invalid which is inconsistent, and the rest of the law will stand. Is this clear? Is this clear? Is this clear? But the court has said that invalid part of law should be severed and declared invalid if really it is severable. Okay. But if after separating the invalid part, the valid part is capable of giving legal effect, then only you can separate it. Otherwise, the court will declare the entire law as invalid. Is this clear? Online students, reply fast. You have to reply fast. Doctrine of severability, did you understand? Entire law is not bad. Some part of the law is bad. Remove that part. But make sure when you remove the part, the remaining law can be used. If the remaining law cannot be used, then in that case, the entire law will be treated as invalid. Next is doctrine of eclipse. Doctrine of eclipse says that any law which is against our fundamental right will not be removed, it will be hidden. In future, if we need that law, we will take that law out by amending the constitution. Okay, so currently the law is inconsistent with fundamental rights. It is inoperative from the commencement of constitution. It is inoperative from which date? 26 Jan 1950. Okay, but we have not killed the law altogether. Okay, the law will remain eclipsed or dormant. Okay, because it is under the shadow of fundamental rights. But the eclipsed or dormant parts will become active and effective again if the prohibition brought about by the fundamental right is removed by the amendment of constitution. This is called as doctrine of eclipse. Doubt, question, query. Is this crystal clear? Constitution of India. Is this point crystal clear to all these students? Fast. Everyone reply with a fire. Yes or no? Yes or no? Braz, Aswin, Soumya, Abhi, Sriram, Hiba, Magdalene, Immortal. Fast. Is this crystal clear? Yes, I am waiting for doubts. Fire. Very good. Very good. Very good. Very good. Very good. Very good. Now, what is the meaning of doctrine of favor? Doctrine of favor is that a person is his best judge and he has the liberty to waive the enjoyment of such rights. Everyone. However, the person must have the knowledge of his rights and that the waiver should be voluntary. What is the meaning of this? What is the meaning of this? Our Constitution of India has given us fundamental rights. Constitution of India has given us fundamental rights. Can you waive off the fundamental rights, the rights given by the fundamental rights? No, you cannot waive them off. But there are certain things that you can waive off. For example, I was supposed to receive 10,000 from someone, or there is a government scheme. Government is going to pay some money to everyone. You have seen that scheme is there, right? All the women will get 2,000, 2,500 rupees. Now, if I want that scheme, I will avail. If I don't, I will waive it off. Full stop. Doctrine of waiver. So this right is based on the premise that a person is his best judge and that he has the liberty to waive the enjoyment of such rights. The person must have the knowledge of his rights and that the waiver should be voluntary. You cannot force a person to waive off his fundamental rights. I hope this is crystal clear to everyone. I hope this is crystal clear to everyone. Doubt, question, query. No doubt, no question, no query. Clear? Yes. Right of equality, Article 14. Article 14. Article 14, we have to understand in two ways. Okay. Now, Article 14 is important. Your institute has asked a question. Equality before law and equal protection of law. In simple language, equality before law means all the persons, no matter rich, poor, this thing. He's a politician, he's a businessman, celebrity, nothing. Everyone will be treated equal in eyes of law. So, Article 14 of Constitution India says that the state shall not deny any person equality before law or equal protection of law. Now, Article 14 says that we are giving guarantee to every person right to equality before law. Equality before law is borrowed from English common law, okay, implying thereby the absence of any special privilege in favor of any individual. Every person, whatever his rank, position, is subject to the jurisdiction of ordinary courts. The second example, equal protection law of law, is based on the last clause of the first section of 14th Amendment of American Constitution. So the blue color part, the equal protection of law, has come from 14th Amendment of American Constitution. It says that equal protection shall be secured to all persons within territorial jurisdiction of Union in the enjoyment of their rights and privileges without favoritism or discrimination. So if there is a person who is handicapped, he wants to apply for driving license, he will be allowed to apply for driving license, because just because he is handicapped, he will not take away his right. Equal protection of law. Just because the person's height is small, or the person has one broken limb, you will leg, or a person does not have 3 or 4 fingers, you will not take away his right to apply for the driving license. If he fails the test, then don't give him the license, but you cannot take away his right. Is this clear? Is this clear? Is this clear? See, as a matter of fact, all persons are not alike or equal in all respect. Application of the same laws uniformly to all of them will therefore be inconsistent with the principle of equality. Of course, mathematically, equality is not intended. Equals are to be governed by the same laws. But as regards unequal, the same laws are not complemented. In fact, it would itself lead to inequality. Okay. Now, let us go down and understand the next concept, scope of Article 14. To whom Article 14 is applicable. Okay. Now, Article 14 forbids class legislation but does not forbid classification. A law has been passed for grant of financial assistance to girl child below the age of 14 years for education. It was contended that there should be equality before law. Can this law be enacted? Yes, it can be passed if the legislation is based on reasonable classification and intelligible differentia. Okay, so I hope this is crystal clear. Permissible classification must satisfy 2 conditions. What are those 2 conditions? That it must be founded on intelligible differentia which distinguishes persons or things that are grouped together. Second, the differentia must have relation to the object sought to be achieved. What is the object that we are trying to achieve for a girl child? What is the object that we are trying to achieve for a girl child? That a girl below the age of 14 years should get school, proper education. This is the object that we are trying to achieve. So even if it looks discriminatory, it is not discriminatory. Is this clear? Next, classification may be found on different bases, namely geographical, according to subject, objects or occupations or the like. In permissible classification, mathematical nicety and perfect equality are not required. It has to be mathematically correct. It is not required. Simple non-identity of treatment is enough. Even a single individual may be treated. Even a single individual may be treated a class by himself on account of some special circumstances or reason applicable to him and not applicable to others. A law may be constitutional even though it relates to a single individual who is in a class by himself. I hope this is crystal clear to everyone. I hope this is crystal clear to everyone. Clear? Clear? Yes. Article 14 condemns discrimination not only by substantive law but by law of procedure. There is always a presumption in favor of the constitutionality of enactment, and the burden is upon him who attacks it to show that there has been clear transgression of constitutional practice. Okay. Now, rational nexus means, I'll tell you the meaning of rational nexus with one example. A student has asked about rational nexus. Okay. Now, let us imagine that a government gives scholarship only to students whose income is below 2 lakh. Okay. Okay. Yes. Government gives scholarship only to students whose income is below 2 lakhs. Now, I have a question for you all. I have a question for you all. Okay. Classification plus connection with the objective. Classification plus connection of objective. So rational nexus means reasonable connection between. Write this down if you want. Rational nexus means reasonable connection between basis of classification and the objective of law. Okay. Basis of classification, why the people are divided into group. Objective of law, what the law wants to achieve. Okay. Now focus. Government gives scholarship only to students whose income is below 2 lakhs. So what is the classification? What is the classification? Students income below 2, above 2 lakh. Okay, this is our first point, which is basis of classification. What is the basis of classification over here? Income below 2 lakh and income above 2 lakhs. And what is the objective? What is the objective? Help economically weaker section or weaker students. I hope this is clear to you all. I hope this is clear to you, beta. Is this crystal clear? Is this crystal clear? Is this crystal clear? Is this clear? Okay. Now, Article 15. Article 15 will be divided into groups. Into 6 groups. How many groups? 6 groups. So, I will write here, not here. Wait. Article 15, 16. Okay. I'll add a page here. Okay. Now, focus on screen, everyone. Article 15, 1, 2. I'll change the color. 3, 4, 5, and 6. Okay. Okay. Now, tell me one thing. Article 1 and 2 says no discrimination. 1 and 2 says no discrimination. 1 says the grounds of discrimination, and 2 talks about places where not to discriminate. So, wait, I'll write it again. What is Article 15.1 trying to tell us? Article 15.1 is trying to tell us the grounds of discrimination. Article 15.2 is trying to tell us places where not to discriminate. Okay. Grounds for discrimination and places where not to discriminate. From here onwards, from Article 15.3 onwards, there is discrimination, and this discrimination is valid. First, did you understand the base of Article 15? Article 15 is divided into 2 parts, 15.1 and 2, and then 3, 4, 5, 6. 15.1 and 2 is saying that you should not discriminate. Okay, but from 3 to 6 onwards, they have said that there can be discrimination. I hope you all are with me till here. You all are with me till here. You all are with me till here. Yes. Are you all with me till here? Are you all with me till here? So Article 15.1 and 2 says that there should not be discrimination. They have given the grounds and places where not to discriminate. But 3, 4, 5 and 6 article are saying in Article 15, 3, 4, 5 and 6 are saying that there are certain discriminations, and these discriminations are valid discriminations. Okay, these discriminations are valid discriminations. Now, what are these valid discriminations? Let us understand one by one. Let us understand one by one. See, 15.1 says that you should not discriminate on religion, race, caste, sex, place of birth, or any of them. 15.2 says that you should not discriminate people to access shop, public restaurant, hotel, places of public entertainments, or use of well, tank, bathing ghats, road, places of public resort maintained wholly or partially out of state fund or dedicated to the use of general public. So did I not say that 1 and 2 is clearly saying that you should not discriminate? But from 3 onwards, they have said that there are certain discrimination that are allowed. Article 15.3 says that state can make special provision for women and children. What is the meaning of Article 15.3? That the state can make special provision for women and children. What is the meaning of Article 15.4? Article 15.4 says state can make special provision for advancement of social and educationally backward class citizens, scheduled caste and scheduled tribes. Now, they have only said that they can make provision for advancement of socially educationally backward class, scheduled caste and scheduled tribe. Till here, are you all with me? Till here, are you all with me? Till this point, is everyone with me? Till this point, is everyone with me? But now in Article 15.5, they have said that if the state feels that socially educationally backward class citizen, scheduled caste and scheduled tribes are not adequately represented, then for them we will make reservation in educational institutions. These educational institutions can be private educational institutions or public institutions, which means private and government institutions, private which can be aided or unaided. I hope this is clear. I hope this is clear to everyone. I hope this is crystal clear. And there was an amendment brought in 2019. This was 103rd amendment, which was 15.6, which says that we can make special provision for advancement of economically weaker section other than SC, ST and social and educationally backward class of citizens. All the students who are watching the session, please tell me, did you understand Article 15? What is the Article 15 trying to tell us? Article 15 is divided into 6 parts. How many parts? 6 parts. First two parts are saying no discrimination. 3, 4, 5, 6 says discrimination is allowed. Article 15.3 says that we can discriminate, we can make special provision for women and children. 4 says that socially and educationally backward class citizens and SC and ST we can make special provisions. Now 15.5 says that what life goes, I did not understand, my dear. Okay, 15.5 says that for them we will make special provisions for admission in educational institution. We'll make special provision for admission in educational institutions. And 15.6 says that we will make special provision for economically weaker section of society other than these people. I hope this is clear to all of you. I hope this is clear to all of you. Is there any doubt? Is there any question? Is there any query to any of the students? Doubt, question, query? No doubt, no question, no query. The concept is clear. Article 15 is clear to everyone. Article 15 is clear to everyone. Very good. Now let us talk about Article 16. Let us talk about Article 16. Okay. Also remember one thing. Economically weaker section, there will be reservation of 10% in total seats. Okay. Economically weaker section, how many seats are reserved? 10% seats are reserved. Now let us talk about Article 16, which talks about equality of opportunity in matters in public employment. Sir, what is the meaning of this? Again, the same thing. Over here, we have to divide it into 6 parts. Article 16.6 is divided into 6 parts, but 16.4 is divided into 2 subparts more. So let us understand everything one by one. You will understand easily. See, 16.1 gives guarantee to all citizens that you will get equal opportunity in public employment. You will get equal opportunity in public employment. 16.2 says that you will not be discriminated on the ground of religion, race, caste, sex, decent place of birth or residence. Okay. So till here, they are trying to tell us there will not be any kind of discrimination. But 3, 4 and 5 says that discrimination is allowed. Now, what kind of discrimination is allowed? Please try to understand. See, Parliament can make law that the state government will appoint only those people who are in that particular area, which means that there can be certain job openings in a state where the residence is equal important. So what is the meaning of this? If you want to appoint a person in a local area, then the person should be from that local area only. He should reside within the same state or union territory before the prior such appointment. Is this clear? I hope you have understood this. See, 16.1 and 2. 16.1 is saying that constitution has given guarantee to everyone in public employment, which means government jobs. Okay, there will not be any discrimination. But 16.3 says that residence can be an important factor for giving jobs. So there is a discrimination on the basis of residence. Next is 16.4. It says that we can make provision for reservation of appointment in favor of backward class citizen if the state feels that the backward class citizens are not adequately represented. Now 16.4a is talking about scheduled caste and scheduled tribes. We will make reservation in promotion for these people. What is this article 16.4a trying to tell us? That for scheduled caste and scheduled tribe, we will bring reservation in promotion. We will bring reservation in promotion. What is the meaning of this? In promotion, we will give first chance to those people who belong to scheduled caste and scheduled tribe. Is this clear? Is this clear? Now, also, whenever we talk about 16.4b, it says that we will keep vacant seats carry forwarded if people from scheduled caste, scheduled tribe or other backward class citizens are not represented adequately in government jobs. We will keep seats reserved for them, and the reserved seats which are not filled, let us say that there were 100 seats. Out of 100, 50% is reserved. Out of 100 seats, 50% is reserved for SC, ST and backward class citizens. Okay. Out of 50 seats, only 30 were filled. So what is pending? 20 seats are still vacant. We will not give these 20 seats to other open category people. We will carry forward. We will carry forward these seats to the next year. I hope this is clear. I hope this is clear. I hope this is clear. So 16.1 says equal job opportunities in government jobs. 16.2 says no discrimination on the grounds of religion, race, caste, sex, place of birth, residence. But 16.3 says that residence can be an important factor. 16.4 says that government can make special provisions for backward class citizens. 16.4a says that government can bring reservation in matters of promotion. Government can bring reservation in matter of promotion. Promotion for whom? Scheduled caste and scheduled tribe. Then 16.4b says that if scheduled caste, scheduled tribe or other backward class citizens are there, for them also, if the seats which are reserved, which are not filled, we will carry them forward. Also, how many seats are reserved for scheduled caste, scheduled tribe and other backward class citizens? 50% seats are reserved. Is this clear? Then comes 16.5. Now 16.5 is very interesting. If I belong to a particular religion and I want to work in an organization of different religion, I can be stopped from working there, and this is not considered as discrimination. Then comes Article 16.6. Article 16.6 is for economically weaker section of citizens. Article 16.6 is for economically weaker section of citizens. 10% of seats will be reserved for economically weaker section of society. I hope this is crystal clear to all the students who are watching the session. Is there any kind of doubt, any kind of question, any kind of query to anyone? Article 15 and 16 is clear to everyone? Yes. Article 15 and 16, is it clear to everyone? Reply fast. Raja Varaman, Aswin, S. Sridhar, Magdalene, Aishwarya, Brush, Soumya, Abhi, Iba. Clear? Very good. Now put a star mark. Thank you so much. On Article 19, they give guarantee to certain fundamental rights. Freedom of speech and expression, assemble peacefully without arms, form association, union or cooperative society, move freely throughout the territory of India, reside and settle in any part of territory of India, practice any profession, carry on any occupation, trade or business. But these freedoms are not absolute. There are certain restrictions. These freedoms are not absolute. There are certain restrictions. The Constitution of India has given freedom of these 6 things to all the citizens of this country. Okay, these freedom are given to all the citizens of this country. Okay, but there can be reasonable in these freedoms are not absolute. There can be reasonable restrictions. Okay, so the Constitution under Article 19.2 to 19.6 permits the imposition of restrictions on this freedom subject to following condition. If you are taking away this right, the restriction shall be imposed by law and not an executive order. The restriction should be reasonable, and the restriction has been imposed for achieving one or more object. Is this clear? You cannot randomly take away these rights from me. Number one, it should be imposed by law. Law should have certain provisions for imposing these restrictions. Let me give you an example. Section number 144 of CRPC, we all know that when there was COVID-19 pandemic, section 144 was imposed on us, correct? You cannot gather, you cannot roam out, you cannot come out of your house. My freedom was taken away by me, and it was taken away by law. The restriction was reasonable. If someone has medical emergency, you can go out. You want to buy food, you can go out. You want to buy vegetables, medicines, you can go out. Last but not the least, the restriction was imposed for achieving one or more object. Why did we impose the restriction? To achieve object, and the restriction will be taken off once the object is achieved. Now, what are these objectives which the government wants to achieve? First, let us understand reasonableness. See, reasonableness means restriction should be reasonable. If the word reasonable is not there, the government can impose any restriction and they cannot be challenged. My dear, it will continue till 6 o'clock. 2 more hours. 2 more hours I will take. I will complete as many topics as I can, because you have your exams tomorrow. You also have to prepare for self-study. You will get brush up of certain topics which are important, is what I feel. Okay. I hope this is clear. Suprit. Okay. Okay. Now, if you don't add the word reasonable, government can put any restriction they want and you cannot challenge them. This word alone gives right to an aggrieved person to challenge any restrictions of freedoms granted under this article. Okay. Now, the following factors are considered to assess the reasonableness of law. What are the factors that we see? Number 1, objective. Why the restriction has been put. Number 2, urgency, nature, extent of evil sought to be dealt with. Number 3, how far the restriction is proportion to the evil in question. Number 4, duration. Number 5, conditions prevailing at the time when the law was framed. Is this clear? And proving to the satisfaction of the court that the restriction is reasonable is upon the state. So who has to prove that the restriction is reasonable? The state has to prove whether the restriction is reasonable or not. Is this clear? Is this clear? Now, they have defined right of freedom of speech and expression. They have also given permissible restrictions. I will put here 7 marks. What are the permissible restrictions? They will ask you this in exam. You will be restricted from exercising your fundamental rights if it is affecting the sovereignty and integrity of India, if it is affecting the security of the state, if it is affecting the friendly relation with foreign state. Let me give you a real life example of this. You all have heard the name Salman Khan, yes or no? Have you all heard the name Salman Khan? Salman Khan had produced a film called as Battle of Galwan. Okay, I may be wrong with the spelling. I think it is single A, Galwan. Okay. Indian and Chinese soldiers had fought at Galwan Valley. Now I have freedom of speech and expression. I will make a movie and I'll tell the people of this country what had happened. But the defense minister of our country, the defense minister of our country called the producer Salman Khan and said that, sorry sir, you cannot make this movie by using this name. You cannot show China in bad light. It will affect the diplomatic relations with China. So the name of the movie has been changed. You cannot use the word China also. The name of the movie has been changed to Matrubhumi. Okay. And the 40% part of the movie is reshot. So can I say we don't want to hamper the friendly relation with other state, foreign state? That is the reason why we have put the reasonable restriction. Yes, on freedom of speech and expression, we are putting this freedom reasonable restriction because we want to maintain public order, decency and morality, contempt of court, defamation and incitement of offense. Okay. Once we are done with Constitution, I will start with Indian Contract Act, my dear. Don't worry. Okay. I will complete the main parts. So they have explained all the points: freedom of assembly, freedom of association, freedom of movement. Okay. Right to acquire, hold, dispose any property has been removed. Okay. Then freedom of trade and occupation and monopoly. Now, this is important. I will explain the important parts and then I'll go to the main part that you want, Indian Contract Act. Okay. Indian Contract Act and Negotiable Instruments Act is left by students a lot of time because they think that it is easy or they keep it as option. But those questions make us stuck, get us stuck on the paper. Okay. Now, protection against ex post facto law. Simple meaning of ex post facto law is very easy. That if there was no law when I did something wrong, I did something wrong today, there is no law. Now you make a law on it, I will not be punished. Okay. No person shall be convicted of any offense for violation of law at the time of commission. There should be a law. Is this clear? Is this clear? Are laws which punish what had been lawful when done. If a particular law was not an offense according to the law of land at the time when the person did the act, then he cannot be convicted under the law which with retrospective declares the act to be an offense. Okay. So simple language meaning is that if I did something wrong today, something today, it is not wrong as per law today. In future, if government makes a law, I will not be punished in future for doing something today. Ex post facto law. Is this clear? Reply fast so that I can go ahead. Did you understand what is the meaning of ex post facto laws? If I do something today which is not wrong, and in future government makes a law, and now what I did in the past has been termed as illegal, now I will not be punished in future. Okay. Next, protection against double jeopardy, which means I cannot be punished for the same offense more than once. If I have committed something wrong, I cannot be punished for it again. Okay. Protection against self-incrimination. You cannot become a witness in your own case. You cannot be called as a witness in your own case. Is this clear? Is this clear? Then comes Article 21, protection of life and personal liberty. I can marry whomever I want to marry. I can go wherever I want to go. I can get divorced and get married again with whomever I want to marry. No person shall be deprived of life or personal liberty except according to procedure established by law. What is the meaning of this? If you want to take away my personal liberty, if you want to take away my liberty, you can take it away only by the procedure which is established by law. If I am sitting here, you want to confine me, you want to take me to police station, first you show the warrant, then take my liberty away from me. Are you understanding? If you want me not to come out of Pune, or if you don't want me to come out of Bangalore, put a restriction on me by using law. You cannot put random restriction on me if there is no law. See, if I find a gun which is lying on the road, you cannot shoot me directly. There is a procedure and you will follow the process to punish me or to leave me from the jail. Is this clear? Is this clear? Is this clear? There is one case law. There is one case law that you need to remember, and that is Union of India versus Menaka Gandhi. Sorry, Menaka Gandhi versus Union of India. Okay. Now I'm going ahead. And also Satwant Singh Sahni versus APO. and Menaka Gandhi versus Union of India. These are two important points. Now, procedure established by law, I'll explain it in a one point. See, this is Shubham Joshi. You want to take away my rights? You want to take away my rights? Take away my rights using process. Which process? Given in law. If you don't take away my rights using the process given in law, you cannot take away my rights. Is this clear? Is this clear to everyone? Is this crystal clear? Article 21A, right to education, a 3-mark question can be asked. Everyone, Article 21A says the state shall provide free and compulsory education to all children from the age of 6 to 14 years. It is mandatory. Is this clear? Then, right, protection against arrest and detention. Article 21 does not impose limitation on legislature so far as the deprivation of life or personal liberty is concerned, yet a legislative act providing for such deprivation is subject to procedural safeguards provided in Article 22. And if it does not provide any of these safeguards, it shall be declared unconstitutional. Okay. Article 22 does not apply uniformly to all persons and makes distinction between alien enemies, person arrested or detained under preventive detention laws, and other persons. So this is very basic. What is the meaning of preventive detention? Article number 22 talks about preventive detention. What is the meaning of preventive detention? Everyone, what is the meaning of preventive detention? We know that in some locality there is some person who can create nuisance in the area. Let us assume that there is a curfew because of two religion or two communities are fighting with each other. Now in that area where the curfew is imposed, there is a person who can give hate speeches and cause a disruption in the area. Then even before filing the case against him, we can take him and detain him and put him in jail. We are preventing something from happening because we know that this person is a bad person. He can do something wrong. So we are preventing a mishap from happening. That is the reason why we are detaining him. But objective of preventive detention is not to punish a person for having done something, but to prevent him from doing it. We are putting you in detention so that we can prevent you from doing it. Is this clear? Now, whenever there is preventive detention, you should remember your rights. You cannot be detained for more than 3 months unless advisory board has sufficient cause for such detention, has said that there is sufficient cause. So what can I say? You cannot be detained for more than 3 months, but if there is sufficient cause, then you can be detained for more than 3 months. Or Parliament may make law prescribe the maximum period for which any person can be detained under any law. Is this clear? Is this crystal clear to everyone? Then the authority of ordering the detention of a person under preventive detention law shall communicate to him the grounds on which the order for his detention has been made. You cannot just take that person away. You have to communicate him and also give him opportunity of making representation against the order. Is this clear? Is this clear? Preventive detention is clear. We are not putting you in jail for doing something. We are putting you in jail from stopping you from doing something. Okay. Then comes right against exploitation. 23 and 24 says there is prohibition of human traffic and forced labor and prohibition of employment of children below the age of 14 years in the factories. Is this clear? Is this clear? Then comes right to constitutional remedies. Everyone, if my fundamental rights are taken away, I will use Article 32 and go directly to Supreme Court. Dr. B.R. Ambedkar has said that Article 32 is the heart and soul of Indian Constitution. Okay, it is the heart and soul of Indian Constitution. Remember one line, ubi jus ibi remedium, which means where there is a right, there is a remedy. What is the use of right when there is no remedy? What is the use of right when there is no remedy? Okay, and when your fundamental rights are taken away, how many writs are there, my dear students? You can file 5 writs in directly Supreme Court. And if you want to go to High Court, you can go to High Court under Article 226. I hope this is crystal clear to everyone. Okay. Now, let us go. DPSP, you read it by your own. DPSP and all, I will not explain. Fundamental duties. this is important. I know that this is very boring, but they had asked this question for 7 marks in exam. What are the fundamental duties under Article 51A? Okay, number one, fundamental duties: abide by constitution and respect its ideals and institutions, national flag and national anthems, cherish and follow noble ideas which inspired our national struggle for freedom. Then, uphold and protect sovereignty, unity and integrity of India, defend the country and render national service when called upon to do so, promote harmony, spirit of common brotherhood amongst all the people of India, value and preserve rich heritage of our composite culture, protect and improve natural environment, develop scientific temper, safeguard public property, abjure violence, strive towards excellence in all spheres of individual and collective activity so that the nation constantly rises to higher levels of endeavor and achievement, and also provide opportunities for education to one's child between the age of 6 to 14 years. Is this clear? These are our fundamental duties, and you must remember almost all of them. Write it in your own words. Sir, can we write this answer in own words? The answer is absolutely fine. This is correct. You can write the answer for this topic in your own words. No one is going to stop you from doing so. Okay. Now, ordinance making power of the president. Do you know what is the meaning of ordinance, or should we skip it? See, they will ask you a question. Article 53. What are the powers of president? Administrative power, military power, legislative power, judicial power. Administrative power means he will execute the laws. Military power means he's command of the armed forces. Legislative power means he can summon or prorogate the legislature. Judicial power means what? He can grant pardon, reprieve, etc. to persons convicted of crime. Granting pardon means what? And reprieve means what? If someone is given death penalty, President of India can cancel that death penalty and convert it into a different punishment. I hope this is crystal clear to all the students who are watching the session. Ordinance making power. See, you should know one thing, that bill is introduced to Lok Sabha, then it goes to Rajya Sabha, and then it goes to President of India for its assent. But if Lok Sabha and Rajya Sabha are not in session, if they are not in session, and this bill is of urgent matter, we want a law to be made on this bill, it directly goes to President of India, and President of India, after he gives his assent to it, it becomes an ordinance. It becomes an ordinance. The same power is given to our governor of the state. President has been given power under Article 123 and governor has been given power under Article 213. I hope this is crystal clear to all the students. Okay. The same power is given to governor under Article 213. And also remember that you need to write these points about ordinance making power of the governor. Do not forget to write these points. Okay. These points are very important. Now, legislative assembly and all is very easy. I'll take you to some concepts which are important. Yes. Power of parliament to make laws on state list. Now, everyone, one important point that you need to remember is normally only state legislature can make law on subject in state list. Do you all know Schedule 7? Schedule 7 is divided into 3 parts. Part 1, List 1, List 2, List 3. Schedule 7, List 1 talks about Schedule 1, List 1, Schedule 7, List 1 talks about. Thank you so much. List 1 talks about central government can make law. List 2 talks about state government can make law. And this talks about concurrent list. Okay. Which means central government plus state government can make laws. Okay. Now. Normally state legislature can make law on subject in state list. Okay. Like police, public health, agriculture, etc. Correct? Parliament cannot interfere. Can Parliament interfere? No, Parliament cannot interfere. Okay. But there are certain exceptional cases. Okay. Number 1 is in national interest. Okay. In national interest, in national interest, the state laws will be handled by central government. Okay. Now, try to remember key points. See, first thing is Council of States. What is the meaning of Council of States? Council of State means Rajya Sabha. Rajya Sabha can pass a resolution with two-thirds of members of majority present and voting in national interest, and they can make law on state subject, state list subject. So if in national interest you want to make law, in national interest you want to make law in the state, then who will make that law? Council of States will take the decision. And how much voting do you need? You need vote of two-thirds of the members present and voting. How much vote do you need? Two-thirds of members of Rajya Sabha should vote. Is this clear? Is this clear? Now Parliament will get power over the state subject. The resolution will remain valid for 1 year. So the resolution will remain valid for how many years? The resolution will remain valid for 1 year. Okay. It can be renewed again. It can be renewed again. Okay. And the law will continue as long as the resolution remains in force. Once the resolution expires, the law does not disappear permanently. Okay. The law remains effective for 6 more months after the resolution ends. I hope this is crystal clear to everyone. I hope this is crystal clear to everyone. Okay. So this point is very important from the point of view of examination. Now comes proclamation of emergency, Article 250. Let us talk about Article 250, proclamation of emergency. Okay. Whenever the central government invokes the Article 352, when national emergency is in operation, okay, then Parliament can make law on any state list subject. Why? Because during national crisis, uniform laws will be made. Uniform laws will be made. Okay. Now, for this, I will write key pointers for you for national emergency. Okay. Not national emergency, I'll write emergency. For this, you need to remember certain points. Write with me. Number 1. Parliament can make law for whole or part of India. Law is effective while emergency continues. Number 1, Parliament can make law for whole or part of India. Law is effective while emergency continues. Third point, after emergency ends, the law remains effective for 6 months. The law remains effective for a period of 6 months. Is this clear? Fourth point, after that, it becomes inoperative. In bracket, I will write except actions already taken, they will remain valid. Is this clear? Is this clear to everyone? Yes, is this crystal clear to everyone? Doubt, question, query. All the students who are watching the session, please respond. Is this crystal clear to everyone or not? Yes. We are about to conclude Constitution of India. We are about to conclude Constitution of India. So please feel free to tell me if you have understood everything or not. Yes, all the students are watching the session. Please respond. Yes. Okay, I'm going ahead. Yes. Now, let us talk about harmonious construction, interpretation of legislative list, plenary powers, harmonious construction, and pith and substance rule. Now, on pith and substance rule, I will write 4 marks. On pith and substance rule, I will write 4 marks. Okay. And harmonious construction also I'll write 4 marks. Always remember one thing. Okay. When two or more provisions seem to be in conflict. What is the meaning of harmonious construction? You might have studied this in interpretation of statutes. When two or more provisions are conflicting in nature, the court tries to interpret them so that the both can work together. Okay. So different entries in the different list are to be interpreted in such a way that conflict between them is avoided and each of them is given an effect. It must be accepted that the constitution does not want to create conflict and make any entry nugatory. Therefore, when there appears a conflict between two entries in two different lists, two entries should be interpreted such that each should be given its effect. Is this clear? Is this clear? The purpose, the scope and meaning of one may be restricted so as to give meaning to the other also. Is this clear? Is this clear? Is this clear? Is this clear? Okay. Now, for pith and substance, you will write with me pith and substance. As I said, I have a revision book. In my revision book, I have added certain key points in simple way. I am not using the revision book. Why? So that you all study from the module. So whatever is written in my revision book, I will make you write so that you remember this. This question has been asked a lot of times in your exam, pith and substance. Okay. So write down the meaning of pith and substance. Meaning, to determine whether a legislature had power to make law. What is the meaning? What is the meaning of pith and substance? To determine whether the legislature had power to make law. Second point in that, courts will look at real nature, true object, and substance of law. Did you write this? Did you write this? Done? Done. So conclusion, pith is equal to heart of law, the law, substance, which equals to real object of law. Done? So if you look closely, the rule of pith and substance means that where the law in reality and substance fall within an item on which legislature which enacted the law is competent to legislate, then such law shall not become invalid merely because it incidentally touches a matter outside the competence of legislature. Okay. In federal constitution, as was observed by Goyer CJ, Chief Justice, it must be inevitably happen from time to time that legislation, though purporting to deal with a subject in one list, touches also upon a subject in another list, and the different provisions of the enactment may be so closely intertwined that blind adherence to a strictly verbal interpretation would result in a large number of statutes being declared invalid because the legislature enacting them may appear to have legislated in a forbidden sphere. Okay, I hope this is clear. I have given easy example to you. Next comes colorable legislation. Colorable legislation, write down the heading with me. Colorable legislation. Colorable legislation. What is the meaning of colorable legislation? See, I'll give you an example. Okay. State cannot impose tax because tax comes in central list. Correct? So now, what if the state government makes a law and says that we are collecting developmental fee, but it is the same tax which has been prohibited by central law? So, what a legislature cannot do directly, it can not do indirectly. You are not allowed to do it directly, so you'll not be allowed to do it indirectly as well. Is this clear? So, if law looks constitutional on surface, the law looks constitutional on surface, but the intention to make the law is something else, but actually tries to achieve something beyond the legislature's power, then it is called colorable legislation. So can I say that the law is trying to wear a mask, that the intention is this, but when you lift the mask, you understand the real intention, that the lawmaker was not supposed to make this law, but still he made it. Is this clear? Is this clear? Freedom of trade, commerce and intercourse is also important, everyone. Please read this at home. Okay. Judiciary is also important. I hope you will understand. Writ, all the writs are also important. Habeas corpus means to have the body. To have the body. Okay. Mandamus means on whose. Sorry, mandamus means we command. Mandamus means we command. Now, what is certiorari and what is prohibition? What is certiorari and what is prohibition? Quo warranto means on whose authority. Now there are two topics, certiorari and prohibition. What is the meaning of certiorari and prohibition? Everyone, certiorari and prohibition. These 5 writs can be asked in exam for 6 to 7 marks. You know the meaning, but prohibition and certiorari is confusing. So this is issued when an inferior court is preventing the latter from usurping jurisdiction which is not legally vested in it. Okay, when a tribunal acts without or in excess of jurisdiction, writ of prohibition can be asked for. It is generally issued before the trial of the case. So prohibition means court has no jurisdiction. The court has no jurisdiction, yet it took the case. So before the trial starts, you can go to the upper courts. Certiorari means the court which had no jurisdiction has given a judgment. So you want to quash the judgment, you use certiorari. Okay. So prohibition is before the trial starts. Certiorari is after the judgment has been given. It is available to any person wherever any body of persons having legal authority to determine the question affecting the rights of subjects and having the duty to act judicially in excess of their legal authority. Okay. Quo warranto means on whose authority. Is this clear? Is this clear to everyone? Yes. I hope you have read everything properly. I have explained the main parts which are asked in examination, and with this, with in 2 hours, we have completed the two topics of our JIGL. We have very less time. That is the reason I'll not be able to explain everything in detail, but I've tried to cover everything as much as I can. Till here, was everything helpful to you all? Till here, was everything helpful to you all? Put fire. You should have fire in you. You should not be like Pushpa. You should be real. Someone real, not like Pushpa. He's only fire in movies. You be real. Have fire in you. You have your exams tomorrow. Okay. You have your paper tomorrow. Yes. Is this crystal clear to everyone? Is this crystal clear to everyone? Now, should we start with Negotiable Instruments Act first, or should I start with Indian Contract Act first? Tell me fast. Should I start with Negotiable Instruments first? Should I start with Negotiable Instruments first? Take all the important concepts. I'll explain all the important concepts to you. Yes, tell me fast. Should I start with Negotiable Instruments first? Okay. I'll explain all the concepts to you as quickly as I can. Okay. Now, this is A, this is B. B has given goods. Okay. A says, I will pay after Contract Act. Okay, Contract Act. Two are saying Contract Act, one is saying Negotiable Instruments Act. Everyone fast. Be fast. Reply fast. If there is majority of Contract Act, I'll start with Contract Act and then I will start with negotiables. Fast. I can start with Contract Act, but I want majority to win. Fast. It is your exam tomorrow. It is not a normal class. It is not a regular session. Fast. Two students have written Contract Act. Aswin and Braz has written Contract Act. Other students, contract. Okay, I'll start with Indian Contract Act then. Okay, very good. Okay, thank you for informing. Contract law. Now, whatever I tell is important, and I'll also tell you what type of questions they ask in exam majority of the times. Okay, now we all know that we all know the definitions, right? You all know the definitions. Yes or no? Yes. What is the meaning of agreement? Okay. See. First, the definition of agreement. First, the definition is of agreement. So we are starting with Indian Contract Act. First definition of agreement. Every promise and every set of promise forming consideration for each other is agreement. My promise that I will sell my phone to you. Your promise that you are giving money to me. Forming consideration for each other is an agreement. Is this clear? Then comes promise. What is promise? When a person to whom proposal is made says yes to the proposal is said to be accepted. And once a proposal is accepted, it becomes a promise. Correct? Once a proposal is accepted, it becomes a promise. Okay. So an agreement comes into existence when one party makes proposal or offer to other party and other party signifies his assent. Okay. And agreement is nothing but offer and acceptance. So first there will be offer plus acceptance equals to agreement. It is nothing but promise plus set of promise forming consideration for one another. Okay. And what is the meaning of contract? Contract is nothing but agreement enforceable by law. What is the meaning of contract? Contract is agreement enforceable by law. Now comes agreement. Agreement, you need two persons and you need consensus ad idiom. What is the meaning of consensus ad idiom? Consensus ad idiom means same thing in same sense. This shirt is white. I have two cars. I have one Harrier and I have a Creta. I have Harrier and I have a Creta. I want to sell my Creta. You think that I want to sell Harrier. Is there consensus ad idiom? No, there is no consensus ad idiom, which means meeting of minds. Okay. Same thing in same sense. Okay. Same thing in same sense. Okay. Now, obligation. Obligation means duty. Obligation is your legal duty to do something or not to do something. I promise I will do this. I promise I will not do this. Obligation can be doing something, obligation can be not doing something. Okay. And a contractual obligation arises from bargain between the parties to the agreement who are called as promisor and the promisee. Okay. Now, when I give you a proposal and you accept it, when I give you a proposal, you accept it, there will be certain rights and obligations. If you want to understand this in a very simple way, A says to B that he wants to sell his car at 1 lakh. B says yes. Can I call this as an offer? Can this yes be called as an acceptance? One is offer, another one is acceptance. Now I have a question for you all. Tell me the right and obligation of A. Tell me right and obligation of B. Right of A is money. He's giving car, right? So he has the right to receive money. His obligation is to give car. Right of B, to receive car. Obligation of B, to pay money. Is this clear? Did you understand rights and obligation? Did you understand rights and obligation? Now, all agreements are not contracts, but all contracts are agreements. I repeat again. All agreements are not contracts, but all contracts are agreement. Okay, what is the meaning of this? I can agree on to anything. Ashwin, I'll ask you to murder Supreet. We have made a promise, we have agreed. Will it become a contract? No, because a contract is something which is enforceable by law. Contract is something which is enforceable by law. So all agreements are not contracts, but all contracts are agreements. There are certain agreements where there is no intention to create legal relation. There are certain agreements where there is no intention to create legal relation. Agreements relating to social matter, an agreement relating to domestic arrangement between husband and wife. Can anyone tell me the case law of husband and wife, the landmark judgment? Can anyone fast tell me the landmark judgment? Sorry, can anyone tell me the landmark judgment? Yes, landmark judgment. Domestic arrangement of husband and wife. Balfour versus Balfour case law. Yes or no? Now, agreement relating to social matter. They have asked this question multiple times in exam for 4 marks. If I invite to you on my birthday party, you spend a lot of money to travel all the way from your house to my house, and when you come to my house I am not there or I cancel the birthday party, can you sue me? No. I invite to you for my wedding. You come to my wedding, but you promise to come to my wedding. I make all the arrangements for you and you don't come. Can I sue you in court? No, I cannot sue you in court. Is this clear? Is this clear to everyone? Is this clear? Is this clear? Agreement relating to social matter, an agreement between two persons to go together to cinema for walk does not create a legal obligation. Okay. If I promise you to take you for dinner and I break the promise, you cannot sue me. Domestic arrangement between husband and wife. You know what had happened in this case? There was a husband who promised his wife that he will pay a fixed amount of money to her as housekeeping allowance. The wife had an affair with someone else. The husband got to know about it. He stopped paying the money. The wife sued the husband. Can the wife sue the husband? The answer is no. The wife cannot sue the husband. Why cannot she sue the husband? Because it was a domestic arrangement between husband and wife. Is this clear? Is this clear? So, everyone, intention to create legal relationship. Always remember one thing, whenever people make an agreement, the intention is to create legal relation. Okay. So, intention to create legal relation is an essential element of valid contract. There must be intention among parties that agreement should be attached by legal consequences and legal create obligation. If there is no such intention, then there is no contract between them. So no legal relation intention, no contract between the parties. If the parties do not have any legal intention to create legal relation, there is no contract between them. Agreements of social or domestic nature do not become or create legal relationship as they are not contract. Is this clear? Is this clear? Now let us understand about other types of contracts such as contingent contract, then essential elements of valid contract, offer and proposal, kinds of offer, then rules governing offer, invitation to offer, revocation, mode of revocation, acceptance, and then consideration. Okay. Now, first things first. Do you want me to explain everything line by line, or do you want me to explain certain topics fast? Do you want me to explain everything line by line, or you want me to explain certain topics and case laws fast? Like contingent contract, I'll have to explain in detail. Yes. Yes, fast. Explain everything. Okay. Important topics and case laws. Okay. Fast. Okay. Srinidhi is saying line by line. Okay. So there is a mixed thing. So, okay, I'll explain everything, but I'll be a bit fast. Okay. Now, let us talk about contingent contract. What is the meaning of contingent contract? What is the meaning of contingent contract? Contingent contract means to do something or not to do something if event collateral to such contract does or does not happen. I will pay the money to you if the ship comes to India. So my liability will start only when the ship comes to India. I will do something not to do something when the event happens or does not happen is called as contingent contract. Okay. I will pay money to you if your goods are destroyed. If your goods are destroyed by fire. My liability will start only when your goods are destroyed, or else I'll not be liable. Contingent contract. To do something, not to do something when event collateral to such contract happens or does not happen. Is this clear? Contracts of insurance and indemnity guarantee are popular instances of contingent contract. Okay. Rules governing contingent contract. Rule number one. If the contract is depending on happening of future event, it is on happening of future event, the contract will be void until that event has happened. You cannot enforce the contract unless and until the event has happened. Number one, the contract is for happening of event, blue color line. The contract will be valid only when the event happens. Number two, non-happening of uncertain future event. Now, the contract will be valid only if the event does not happen, which means it should become impossible. Though I can enforce the contract when the event does not happen, not before that. Next, contingent contract upon how a person will act at unspecified time. What is the meaning of this? I will pay money to you if B marries C. Okay, it depends on how a person will act. Is this clear? Next, I will pay money to you if the event happens within a fixed time. If the ship returns in 1 year, then only I'll pay money to you. If the event becomes impossible, then I cannot sue you. Okay. So happening of an event within a fixed period, then at the expiration of time and the event has not happened, then such event has become impossible and the contract will become void. The contract should happen within fixed time. After the fixed time has expired, if the contract happens, I will not be liable. If it becomes impossible, I will not be liable. Okay. Then the contract should not happen within fixed time. The ship should not come to India within 1 year. If the event happens, then I'm not liable. The ship should not come to India in 1 year. So it may be enforced by law when the fixed time has expired and the event has not happened. So over there, it should happen in the D point, and in E point, it should not happen. Both are the same. So can I say that A, B, D and E are brothers and sisters? A is saying event should happen. B is saying event should not happen. D is saying event should happen in fixed time. E is saying event should not happen in fixed time. They are brothers and sisters. Is this clear? Is this clear? And last but not the least, agreement to do or not to do anything which is impossible. If it is such that, then the agreement will be considered as void. Is this clear? Now, essential elements of valid contract is very easy. Offer or proposal by one party and acceptance should be there. Intention to create legal relation should be there. There should be lawful consideration. Lawful object should also be there. Okay. Party should be legally capable of contracting. Consent should be genuine. Object should be legal and not opposed to public policy, and consideration should be legal, not opposed to public policy. Terms should be certain or capable of being made certain. Terms should be certain or capable of being made certain. I will give you one quick example for this. They have asked this question in exam. A sells different types of oil. B gives rupees 100 to A and says give oil. Now in this case, A is not liable. Why? Because he sells different types of oil. You were not certain which oil you want for 100 rupees. Sorry, the contract is void. But if it is capable of being made certain, what is the meaning of capable of being made certain? A sells only coconut oil. B gives rupees 100. Is it capable of being made certain? Did he say how much oil he wants? No. But is it capable of being made certain? Yes. Then the contract will be valid. Is this clear? Also, the agreement should be capable of performing. It should not be impossible. Is this clear? Now, there will be offer and acceptance. Now, what is offer or proposal? Okay. Now, what is the meaning of this? Please focus. As per the definition, when one person signifies his willingness to other, when one person is telling the other person that he wants to do or not to do something, why is he saying that? So that the other person says, yes, I am telling you I will do something or I will not do something. Why am I telling you that? So that you say yes, that you do it for me or you don't do it for me. Whenever I am doing this, I am said to make a proposal. So when a person signifies that he is willing to do something or not to do something for other person, why is he doing that? So that the other person says yes for me to do something or not to do something. Me giving my willingness to do something or not to do something is a proposal. Is this clear? Is this clear? Now, kinds of offer. Number one is particular or specific offer. Everyone, example number one. I want to sell my car only to advocates. Advocates are thousands and lakhs and crores in India. But am I being specific? Yes. So specific or particular or general of particular or specific offer means offer given to a particular person, certain person only, and it will be accepted only by that person only. No one else can accept it. General offer means offer given to public at large. General offer means offer given to public at large. If I put on YouTube or Instagram that I want to sell my bottle, I put this on Instagram, I want to sell, it can be accepted by anyone, general public. Okay. What is the meaning of cross offer? Cross offer means there is no acceptance. I want to sell my car to you. You also want to buy my car from me. You give me an offer, I give you an offer. This is cross offer. Everyone. When two parties give offer to each other, it is called as cross offer. Everyone. It is called as cross offer. Is this clear? Is this clear? There is no acceptance. A offers to sell his old mobile phone to B at 10,000. B offers to purchase his mobile phone at 10,000. There is no concluded contract. There is no contract. I have made an offer. You have made an offer. It is a cross offer. There is no contract between the parties. It is just an example of cross offer. It is just an example of cross offer. Is this clear? Then comes open, standing or continuing offer. What is the meaning of this? The offer will be remain open for a particular period. Okay, for a particular period. Standing offer or open offer means what? Where a person offers to another to supply specific goods up to a stated quantity or in quantity, any quantity which may be required at a certain rate during fixed period, he is making a standing offer. Is this clear? Is this clear? And once an offer is accepted, then the offer is ended. And if you don't accept the offer in given time, then the offer will stand lapsed. Okay. What is the meaning of counter offer? Counter offer means I want to sell my mobile phone to you for 10,000. You tell me, no sir, I will buy it for 9,000 rupees. When I gave you offer for 10, you gave me a counter offer. The original offer has gone. Now we will discuss on the new offer that you have made. 10,000 is my offer. 9,000 is your offer. You have countered to my offer. An offer made against an offer already made. what was the offer that I made? I want to sell my mobile phone for 10,000 and you made another offer for 9,000. Here, the contracts can be made only after acceptance of counter offer. Okay. Contract by post, contract over telephone. Contract by post is very easy. Everyone. An offer by post may be accepted by post. Offer is made only when it actually reaches the offeree and not before. What is the meaning of this? I sent a letter to you that I want to sell my car. The offer is complete only when the letter reaches to you. Okay. Now, acceptance is made as soon as the letter is posted. What is the meaning of this? Let me explain it in a very simple way. A gave an offer to B that he wants to sell his car by letter. He sent the letter on 10th May. B opened the letter and it reached the letter. The letter reached to B on 15th May and he opened it on 15th May. So the offer is complete. Complete on 15th May when B reads it. Correct? Now, B has sent acceptance letter on 20th of May. The letter reaches to A on 1st June. Acceptance is complete the day when B sends the letter. When is the acceptance complete? The acceptance is complete when B sends a letter to A. Is this clear? Is this clear? Is this clear? You send the letter on 20th May, acceptance is complete. Now A cannot cancel the contract after 20th May. He cannot say that the letter came to me on 1st June. What is my fault? Is this clear? Is this clear? Okay. But B can cancel his letter of acceptance before it reaches to A. I hope this is clear. So B, if he wants to cancel the acceptance, he can do that before A comes to the letter comes to A. Before 1st June, B can cancel his acceptance, but A cannot cancel his offer after 20th of May. I hope this is crystal clear to everyone. It is a bit confusing, but it is very simple. A sent a letter on 10th May to B. The letter reached B on 15th of May. The offer is complete when B reads the letter. Now B has sent his acceptance on 20th of May. So if A wants to cancel the offer, he has to cancel the offer before 20th of May. After 20th of May, A cannot cancel. Why? Because the acceptance is complete from the point of view of B on 20th of May. But B can cancel his acceptance before 1st of June. This is what is given here in the theory. I hope this is clear. Contract over telephone are similar to normal contract. If the voice is not clear, if the call drops before the other person gives his acceptance or listens to the offer or the contract is not complete. Full stop. Okay. Now, rules governing offer. Whenever you are making an offer, your offer must be clear, definite, and complete. It must not be vague. Number 2, offer must be communicated to the offeree. Number 3, you can communicate the offer by words or it can be implied by conduct. So if I am stopping auto rickshaw while looking at you while you are walking on the road, my offer is not by oral or in written form, it is by my action. It is by my action. If I stop the bus at bus stop, I am trying to show that I am giving an offer that you can come and sit in the bus. It is called as implied offer. It is called as implied offer. Okay. It is called as implied offer. Now, fast. Tell me how many of you know this case law. I will put a star mark over here. I'll give this case law 5 on 5 stars. How many stars? 5 on 5 stars. Fast. Tell me how many of you know the case law Carlyle versus Carbolic Smoke Ball Company. Yes. How many of you know the case law of Carlyle versus Carbolic Smoke Ball Company? Fast. Five-star example, 5-star case law. How many of you know it? Carlyle versus Carbolic Smoke Ball Company. How many of you know the case law? Yes. How many of you know the case law of Carlyle versus Carbolic Smoke Ball Company? Yes. Tell me, how many of you know the case law of Carlyle versus Carbolic Smoke Ball Company? No? Ashwin doesn't know the case law. I know the case law. Srinidhi is saying she knows the case law. Don't know. Okay, very good. See, this is a very important case law. I will give you a story. There was a company called as Smokeball Company. The name of the company was Smokeball Company. What was the name of the case company? Smokeball Company. I repeat, what was the name of the company? Smokeball Company. Okay. The company put an advertisement in the newspaper that their medicine, if you consume their medicine and something wrong happens to you, we will pay a fine, not a fine, we'll give a reward of 100 rupees. Okay. So I have a company. Some of you know, some of you don't know. Okay, very good. So there is a company which puts in newspaper an advertisement that if someone consumes our medicine and falls ill, we will give a 100 rupee gift. Okay. There is a girl, her name is Carlil. Okay, there is a girl, her name is Carlil. She sees the newspaper ad, she goes to the medical shop, buys the medicine and consumes it. But what happens is she falls ill. She falls ill after consuming the medicine. So she goes to the company and says that you had offered a reward that if you fall sick, you will pay the money. The company said, but you did not tell us that you are accepting the offer. You did not notify us that you are accepting the offer. Everyone, remember one thing. Remember one thing. Remember one thing. If the offer is made to the world at large, it is called as general offer and it can be accepted by any member by fulfilling the condition given in the offer. What was the condition given in the offer? You buy the medicine, take the medicine. If you fall sick, we'll pay the money. The girl, she bought the medicine, she ate the medicine and she fell sick. Now the question for you all is the company liable to pay the money? Yes. The company said that you did not tell us that you have purchased the medicine. You have not shown the acceptance to us. Idiots, this was a general offer. In general offer, if you fulfill the condition, it is deemed that you have accepted the offer. Is this clear? So who won the case? The girl won the case. I hope you have understood the story. Okay. Now, offer and invitation to offer. Put a star mark over here. I'll put 3 out of 5 stars. Everyone, offer versus invitation to offer. What is the meaning of offer and invitation to offer? Everyone, whenever goods are displayed on a shelf, they are not selling it to you, they are not offering it to you, they are inviting you to give an offer. Whenever goods are kept on a shelf, they are not offering it to you in a shop, they are telling you that you give us an offer and we will accept it. So for example, if you know the term called as bidding, So this is a person called as Mr. A. He has some rare artifacts. in his shop. He puts in newspaper an advertisement that he wants to sell Egypt pots. Okay. Now the newspaper ad is seen by a lot of people. A lot of people have seen this ad in newspaper that Mr. A wants to sell his Egyptian pots. Now, is this advertisement an offer? No, this is not an offer. This is an invitation to offer, which means you all come tomorrow to my house and you all make an offer to me. He will say, I want to buy it for 10,000. He will sell for 20,000 to, he will say 30,000. Everyone is giving an offer to A. I have invited you to give me an offer. This is called as invitation to offer. Okay. So invitation to an offer is a communication to invite persons or public for making an offer. I am inviting you to make an offer. Okay. Is this clear? Invitation to treat or invitation to make an offer. Mere statement of intention. Announcement of coming auction sale is not an offer. Mere communication of information in course of negotiation is not an offer. Okay. An offer that has been communicated properly continues as such until it lapses or until it is revoked by the offer or rejected or accepted by the offeree. Very simple. Nothing in detail has been given by the institute. They have only given basic topics. So what is the meaning of invitation to offer? You come, I am inviting you to make me an offer and then I will accept and then it will become a contract. Okay. Now lapse of offer. Section number 6. I will put 5 out of 5 stars for this. Lapse of offer. Lapse of offer can be asked in exam for 3 to 4 marks. Lapse of offer can be asked in exam for 3 to 4 marks. What is the meaning of lapse of offer? I gave you an offer. The offer will get over if you do not accept the offer within specified time. I made an offer and I told you that you have to accept the offer within 6 days. You have to accept the offer within 6 days. Or I give you a date that you have to accept the offer by 15th of June. If you don't accept the offer before 15th of June, after 15th of June, the offer has lapsed. Okay. And if no time is specified, then it will be called as reasonable time or reasonable offer. Is this clear? Next is offer will lapse if it is not accepted in the mode prescribed. What is the meaning of this? I have told you that if you want to accept the offer, give me an email. You sent a SMS to me, offer is not accepted, offer has lapsed. Next, I gave you an offer and you rejected it. The offer has lapsed. Or the offeror or offeree dies before the acceptance. I gave you an offer, before you could say yes, I died. Or before you could say yes, you died. The offer has lapsed. Acceptor fails to fulfill a condition before an acceptance. You want to buy the car? First, you have to tell me what you have to buy a coupon. You have to buy a token. If you're ready to buy a token, then only you will accept the car's offer, or else you will not. So if you want to accept my offer, I am giving you an offer. I want to sell something to you. But before that, there is a condition. So if you want to accept it, first you fulfill the condition and then the offer is yours for acceptance. Last but not the least, if you make a counter offer to me, then the original offer is considered as rejected. So what is the meaning of this? A told B that he wants to sell his car for 5,000 rupees. A wants to sell his car for 5,000 rupees to B. B says he's ready to buy for 4,000 rupees. The moment he says this, the green color part is called as original offer. This is your original offer. This red color part is called as counter offer. The moment other party, this is offeree, this is offerer. Okay, the moment counter offer is placed, original offer is rejected or lapsed. Is this clear? Is this clear to everyone? Is this crystal clear to everyone? Is this crystal clear? Yes. If you want to cancel the offer, you can cancel the offer before acceptance. I'll write one here. Revocation of the offer by offerer can be done any time before acceptance. Offer can be revoked any time before acceptance. Is this clear? Is this clear? But if you are revoking the offer, you have to communicate it to the offeree. See, I want to sell my car to you. Now my mother tells me, are you idiot? Why are you selling the car? So I tell my mother, okay, I will tell that person that I don't want to sell the car. I gave you an offer. I want to revoke that offer. I want to cancel that offer. I have to communicate the same thing to you. Until unless I don't communicate to you, it will not be considered as revocation. And if you say yes, then I have to sell my car to you. Or else you will treat it as breach of contract. You will treat it as breach of contract. Sir, how do you cancel? Or how do you revoke? How do you revoke an offer? How do you revoke a proposal? Number one, by communication of notice of revocation by proposal. I gave you an offer. I am communicating it to you. Number two, the proposal is revoked by lapse of time prescribed in the proposal for the acceptance. What is the meaning of this? I told you to accept it within 2 hours. You did not accept. Time is over. Now you cannot accept it. I have revoked the offer. Or if no time is specified, you are coming and telling it to me that you want to buy my car after 6 months. Sorry, that reasonable time has lapsed. Next, I put a condition. You failed to fulfill the condition. I will revoke the offer. Death or insanity. Okay. And if the fact of death or insanity comes to the knowledge of acceptor before acceptance. Okay. Is this clear? Is this clear? Now, what is the meaning of acceptance? Let us understand the meaning of acceptance. Okay. Now we are going to understand the meaning of acceptance. Okay. See, what is the meaning of proposal? When a person to whom proposal is given, when a person signifies that he wants to do, shows his willingness to do something or not to do something, it is called as proposal. Correct? And once the proposal is accepted, it becomes a promise. So when does a contract emerge? Contract emerges from acceptance of the offer. Is this clear? Meaning of acceptance is assenting by the offeree to an offer. Assenting means what? Saying yes to the offer. Assenting means what? Saying yes to an offer. Okay. Now, rules governing acceptance. How can you show acceptance? by words spoken or written. It can also be implied by conduct. If I have given a particular mode of acceptance, method of acceptance, you must accept it in the same manner. It must be unqualified and absolute. What is the meaning of unqualified? It must be unconditional. What is the meaning of unconditional? If it is conditional, then it is counter. Correct? So whatever you accept, it should be unconditional. Okay. A counter offer or conditional acceptance offer operates as rejection. Okay. Last but not the least, acceptance must be communicated to the offerer, for the acceptance is complete the moment it is communicated. Acceptance will be complete only when it is communicated, or else it will not be considered as a valid acceptance. Is this clear? See, mere silence on part of offeree does not amount to acceptance. I gave you an offer, you are quiet. Mere silence does not amount to acceptance. Mere silence does not amount to acceptance. Is this clear? Is this clear? Is this clear? Now, if offer is one which is accepted to be accepted by acting upon, no communication of acceptance is needed. What is the meaning of this? I told you that when whoever buys the medicine from my shop, if he falls sick, we will pay reward. There is nothing to be done by you. Only thing you have to do is you have to act on the offer. You acted on the offer. You purchased the medicine. You took the medicine. The offer is accepted. Is this clear? Is this clear? Acceptance must be given within reasonable time and before the offer lapses or is revoked. Easy. Now, Lalman Shukla versus Gauridat. How many of you know about this case? Fast. Tell me fast. This is an important case law, has been asked in exam. So first case law that you need to remember is Carlyle versus Carbolic Smokeball Company. Before that, Balfour versus Balfour. Third is Lalman Shukla versus Gauridat. How many of you know the case law of Lalman Shukla versus Gauridat? Fast. How many of you know the case law of Lalman Shukla versus Gauridat? Fast. How many of you know the case law of Lalman Shukla versus Gauridat? Yes. Shinidhi, Suprit, Rohit knows the case law of Lalman Shukla versus Gauridat. Okay. Shreya Kumar doesn't know the case law. Okay. Okay. Ashwin K7722 knows about the case law. Very good. Other students? Yes, Abhi knows about the case law. I'll explain in a very simple way. हाँ sir, पता है. Okay, very good. A little, yes. Okay, listen to the story. There was a guy. His nephew had come to his house. There was a man. His nephew had come to his house. The nephew went missing from the house. So this guy got tensed and worried. You know what he did? You know what he did? He sent his servant to get the nephew, to look for the nephew and bring him back if he finds him. Okay. So there is a person, his nephew is missing. This person sends his servant to bring the nephew back. Okay. Now, when the servant is gone, this person prints a paper. Whoever finds my nephew will get a reward of 10,000 rupees. So he printed a paper. Whoever brings my nephew will get a reward of 10,000 rupees. Okay. Now, the servant found the boy and he brought the boy home. When he brought the boy home, he saw that pamphlet, reward of 10,000. So the servant told his master, sir, please give me 10,000 rupees. The master said, hey, idiot, are you a fool? Hey, idiot, are you a fool? You were not knowing about the offer. How can you accept it? How can you accept an offer about which you were not knowing? Who will win the case? The master will win the case. Everyone. The servant bought the boy without knowing the reward. He was held not entitled to reward because he did not know about the offer. Everyone. There can be no acceptance of an offer which is not communicated. The offer will not be accepted if it is not communicated. Is this clear? Now, very important, very interesting, very interesting concept, consideration. Okay. Now, see, the topic is pretty lengthy, quite lengthy topic it is. I'll try to cover as much as I can because we have time constraint and you have your exam. You have to also prepare and do self-study, right? See, the topic is ending on 502 page number. Okay, the topic is ending on 502 page number, and currently we are somewhere around on this area. Okay, so I will write about consideration. I will write quick points for you all. Consideration. There are two rules. At desire of promisor and may move from promisee to any other person. Okay, consideration is always at the desire of promisor. What is the meaning of this? If I have not asked you to wash my car, how the hell you washed my car? And if you have washed my car, do I have to pay money to you? No. Why? Because I did not tell you to wash my car. You washed it by your own self. Consideration is at desire of promisor. If I say so, then only do it, right? I am standing at railway station, my bags are with me. A coolie comes there. He sees that I am looking for a train number. He takes the bag and he keeps it in the train and tells me to give money. Do I have to pay money? No. Why? Consideration is a desire of promisor. Consideration is a desire of promisor. Consideration may move from promisee to any other person. Chinnaya versus Ramaya. How many of you know the case law? Fast. Reply fast. How many of you know the case law? Chinnaya versus Ramaya. How many of you know the case law? Consideration may move from promisee to any other person. How many of you know the case law? They can ask you an exam question on this concept. They can ask an exam question on this concept. Exam question can be asked on this concept. How many of you know the case law? Chinnaya versus Ramaya. How many of you know the concept? Fast, fast, fast. How many of you know the concept of Chinnaya versus Ramaya? Fast, so that I'll understand whether you know. Abhi knows the case law. Okay. There was a girl. There was a mother. This is the daughter. Okay. Mother and daughter. Mother gifts a house. Mother gifts a house to daughter and promise that you will pay X amount to my brother, your uncle, mother's brother. Okay, and the girl's uncle. Okay, promise me that you will pay a fixed amount to my brother. The girl says yes. Okay, always remember one thing. Always remember one thing. No consideration, no contract. If there is no consideration, there will not be any contract. If there is no something, what is the meaning of consideration? Something in return. In Latin, we call it as quid pro quo. No consideration, no contract. Consideration means something in return. If there is nothing is in something in return, then there is no contract. Okay. Now, the girl said yes. Now, the daughter started paying money to her uncle. Then she realized that I am paying money to my uncle, but there is no consideration from my uncle that is coming to me. My uncle is not paying any consideration to me. There is no consideration which is coming from him to me. Okay. So she tells her uncle that I will not pay the money to you because no consideration, no contract. Uncle goes to court and sues the daughter. And the court decides the case in favor of uncle. Why? Because the consideration did not come from uncle, but the consideration had come from the mother in the form of house. What is the meaning of consideration may move from promisee to any other person? The meaning is very simple. If I am offering a coaching class to you, the fees is paid by your parents, but I am teaching it to you. There are some children who are sitting on the footpath. I see that they are hungry. I go to a restaurant, I pay the money to the restaurant, I tell the restaurant owner, don't give that food to me, give it to someone else. See, if I'm giving money to you, you're giving food to me. Money is consideration for you. Food is consideration for me. Money and food, consideration for one another. Yes or no? Money and food, consideration for one another. Yes or no? Yes or no? Now, I gave money to you, but the food did not come to me, it went to someone else. Consideration may move from promisee to any other person. Chinnaiya versus Ramaiya is a landmark judgment, landmark case law. Please remember this case law. It is very important. Okay. Is this clear? So, consideration can be of three types. As per Indian Contract Act Section 2, Clause D, it is at desire of promiser. The promisee or any other person has done or abstained from doing. This is past. Does or abstains from doing. Present. Okay. Promises to do or abstain from doing. Future. It is called as consideration for the promise. Consideration will be at the desire of promiser. Okay. If I ask you to do something, then only you will do it, or else you will not do it. Next is consideration may move from promisee to any other person. What is the meaning of this? What is the meaning of this? Consideration will move from promisee to any other person. What is the meaning of this? Either you give it to me or give it to someone else. Okay. Landmark judgment, Chinnaiya versus Ramaiya. Now, what is the meaning of privity of contract? See, tell me one thing. When I paid money to you, the food that you gave, did you give it to a stranger? Yes. The food that you gave, did you give it to a stranger? Yes. So can I say there can be stranger to consideration? There can be stranger to consideration. There can be stranger to consideration, but not to a contract. Privity of contract says that no stranger to contract. It has its exceptional cases, but as of now, understand there should be no stranger to contract. Very interesting case law, Dunlop Pneumatic Tire versus Selfridge Limited. How many of you know the case law? Fast. This can be asked in exam as a question. Fast. This can be asked as a question in exam. Fast. How many of you know the case law? Dunlop Pneumatic Tire Company versus Selfridge Limited. How many of you know this case law? Okay. Only one student knows about the case law. Okay, I'll explain the case law because this case law is important again from the point of view of examination. There was a guy, he had three types of tire. Tire A, tire B, tire C. How many types of tire did A have? Very good, Tara. How many types of tire did A have? Three types of tire were there with A. Tire A price was 500. Tire B price was 1000. Okay. And tire C price was 2000 rupees. Okay. There were three tires, 500, 1000 and 2000. Mr. X, he's Mr. X, sorry, he's Mr. X. Mr. X told Mr. Y that I will sell the tire to you, but promise me that you will not sell the tire below this price. Which means you can sell tire A for 5000, 1000, 1500, 2000, 1500, 3000, but not less than 5000. You will not sell this tire. You will not sell this tire below 1000. And last but not the least, you will not sell this tire below 2000. This was the contract and deal between X and Y. Did you understand? I will sell the tire to you, but promise me that tire A you will not sell below 500, tire B will not sell below 1000, tire C will not sell below 2000. This was the contract between X and Y. Now, X sold tire with same condition to Mr. Z. X sold the same tire with the same condition to Mr. Z, that you will not sell tire A below 500, 1000, 2000. Now Mr. Z sold the tire below the price list to Mr. J. Who sold the tire below the price list? Z sold the tire below the price list. X got angry and he sued Mr. Z. The question is, can X sue Mr. Z? The answer is no. Why? Because they both are strangers to the contract. Correct? They both are strangers to the contract. They both are strangers to the contract. X cannot sue Mr. Z because they are strangers to the contract. Is this clear? So what is the meaning of privity of contract? There can be stranger to consideration. I will pay on your behalf. You will get the benefit. Stranger to consideration, but not a stranger to a contract. X cannot sue Mr. Z. Why? Because of privity of contract. I hope this is crystal clear to all the students. I hope this is crystal clear to all the students. I hope you have understood the case law of Dunlop Pneumatic Tire versus Selfridge and Co. This is what has happened in this case law. Okay, this is what has happened in the case law. I hope this is crystal clear to everyone. But there are exceptional cases to doctrine of privity of contract. What is the meaning of this? Exceptional case means what? What is the meaning of exceptional case? Even a stranger to a contract cannot sue. See, I will write again. There no stranger to contract. That is, stranger to contract cannot sue. Stranger to contract cannot sue, but there are exceptional cases. There are exceptional cases. There are exceptional cases. There are exceptional cases. Exceptional case means what? Even if I am stranger, I can sue. Exceptional case number one, a beneficiary under agreement to create a trust. Okay. What if I enter into contract with you for benefit of my sister? My sister is not a party to contract, but is she a beneficiary? Yes. Then she can sue you. Okay. Is this clear? Next, assignee under an assignment made. What is the meaning? By parties or by operation of law. Everyone, I take insurance policy and the nominee is my wife. If anything happens to me, the money will go in my wife's account and my wife can sue the insurance company because I have assigned the rights to her. Okay. Family arrangements or settlement between male members of HUF which provide for maintenance or expense for marriage of female members. What is the meaning of this? Everyone, it is very simple. There are two brothers. After their father's death, they have decided to separate the property. Okay. They have decided to separate the property, distribute the property equally amongst them. 50% to elder brother, 50% to younger brother. They have decided to separate the property. Okay. Now listen carefully. Very carefully. They both decide in a contract that we will pay a fixed amount to our mother. Okay. There is a family arrangement or settlement between the family members. In that, they have decided that they will pay money to their mother. Now, the mother can sue both the children, even if she is not a party to a contract. Is this clear? Acknowledgement of liability. What is the meaning of acknowledgement of liability? Everyone. A receives money from B for paying to C and admits to C the receipt of that amount. A constitutes himself as agent of C. B gave money to A and told him give it to C. B gave money to A and told him pay it to C. A tells C that I have received the money. Even though the loan contract was between B and C and money was given from A to B. Was there any contractual relationship between A and C? No. Still, C can sue A to recover the money. Is this clear? Next. Where a promisor by his conduct stopped from denying his liability to performance of the promise, the person who is not a party to contract can sue upon it to make the promisor liable. Last but not the least, where a person makes promise to an individual for the benefit of third party, creates a charge on immovable property for the purpose the third party can enforce the promise, though he is a stranger to a contract. Is this crystal clear to everyone? Is there any kind of doubt, question or query? No doubt, no question, no query. Now consideration can be of three types. Okay. Future consideration, executory. Present consideration, executed. Past consideration, something that you received in past. Okay. Consideration is of how many types? Consideration is of 3 types. What are the types of consideration, everyone? What are the types of consideration, everyone? Past, present, and future. Future is called as executory, present is called as executed, past consideration is a consideration in India. So, executory means the performance will be happening in future. Executed means we have performed our act in present itself. Okay. Now, past consideration means I did something for you in past. Now, for that you will pay it to me in future or in present. Okay. Now, rules governing consideration. Okay. Must be supported by valuable consideration. Consideration can be an act of doing something, an act of not doing something. There must be mutuality, which means each party should do or agree to do something. If it is a gratuitous promise, what is the meaning of gratuitous promise? Gratuitous means I am doing it by myself for you, gratuitously. Okay, then that is not a valid consideration. Okay, consideration should be real, not vague, indefinite, or illusionary. Okay, consideration must have some value, it need not be adequate. What is the meaning of this? What is the meaning of this? I have a shop where I sell mobile phones. The price of Apple iPhone is 2 lakh rupees. My brother comes to my shop, he tells me, Bhaiya, I want to buy this phone. I tell him, you pay only 50,000 and take it. Did he give me 50,000? Yes. Is it of some value? Yes. Is it of the adequate value? Is it of 2? Did he give me 2 lakh? I gave him 2 lakh rupees worth of goods, but he paid only 50,000. If I'm okay with it, then the consideration is valid. Consideration need not be adequate. Consideration need not be adequate. It must be of some value. Consideration need not be adequate. It must be of some value. Is this clear? Consideration must be lawful. If the consideration is unlawful, the agreement is void. And consideration must be something more than the promise is already bound to do for promiser. What is the meaning of this? Tell me fast. What is the meaning of this? How many of you know? Important, asked in exam as a case law, as a practical question. Fast. How many of you know of this? Yes, how many of you know this? Fast, fast. Tell me fast. Yes, how many of you know this? There is a case law. Everyone, are you paying extra money for this marathon lecture? No. Consideration must be something more than the promise is already bound to do. I'm already bound to teach you, right? Am I going to ask for extra money? No. What if you tell me, sir, we are ready to pay extra money to you, take the marathon? I'm like, okay. I took the marathon. Now, if you don't pay the money to me, can you sue me? No. Why? Because consideration should be something that the promise is not already bound to do. Is this clear? Is this clear? Now, exceptions to the rule of no consideration, no contract, which means there are certain cases. Again, this is an exam question. I repeat, this is also an exam question. They can ask this concept in exam as question. There are certain cases where even if there is no consideration, the contract is valid. Number one, if it is expressed in writing, registered, and made out of natural love and affection between parties in near relation to each other. So it must be in writing, it must be registered, it must be made out of natural love and affection between parties in near relation to one another. Then even if there is no consideration, the contract is valid. I promise to give my wife a mobile phone. Now this is an oral contract, oral offer. She accepts it. If I don't give her the phone, she cannot take me to the court. But if I give it to her in writing, I register it on stamp paper. I did this out of natural love and affection. Now if I don't give her the phone, she can sue me, even if she is not giving anything to me in return. Next, I am compensating you. You have already done something for me voluntarily. What is the meaning of this? It is very simple. You did something voluntarily for me. You did something voluntarily for me. Okay. I never asked you to do it. But now I feel I should pay something to you. So I make a promise to you that you helped me, right? Now I want to pay the money to you. If I promise that I will pay money to you for something that you did out of love for me, now you can sue me legally and you can ask me to pay the money. Is this clear? Is this clear? If it is a promise in writing, okay, and signed by the person who is supposed to pay a debt barred by limitation of law. In India, there is a law called as Limitation Act. If I give money to you, you have to pay the money to me on the date which you have promised. On the date on which you have promised to pay the money, if you don't pay the money, from that date onwards, I have 3 years to sue you in court. If I don't take you to court in 3 years after that date, then I cannot sue you after the 3 years are over. But if you give me in writing that you will be paying the money to me, even if it is a time barred debt, 3 years have crossed, 7 years, after 7 years, you are coming and telling me, sir, I am ready to pay the money to you, then you can sue me in court. No consideration is required for agency. If I gift something to you, no consideration is necessary. If I give you something as a gift, no consideration is necessary. Is this concept crystal clear to all the students? Now, gratuitous promise, Kedarnath versus Gauri Mohan. How many of you know this case? Kedarnath versus Gauri Mohan. How many of you know this case? Yes. Fast. How many of you know this case? How many of you know this case? See, you came to me that, sir, will you give donation? I say, no, I will not give any donation. Then there is no contract. Even if I say I want to give donation, there is no contract because you cannot force me. But if I promise that I will give you donation, and then because of my promise you incur some expense, then in that case you can sue me. This is what is given over here. Okay? Is that clear? Is that clear to you all? The terms must be certain. What is the meaning of this? The terms must be certain. What is the meaning of this? Everyone. See, parties must agree on the terms of their contract. They must make their intentions clear in the contract. Same thing in same sense should be there. Mutually agreed it should be there. The contract is always based on consensus ad idem. What is the meaning of this? Same thing in same sense. What is the meaning of consensus ad idem? Same thing in same sense. The intention should be there to create legal relation, and there should be consideration. Without consideration, there is no contract. Without consideration, there is no contract. Is the concept crystal clear to all of you till here? Is there any kind of doubt, question or query to any of the students? No doubt, no question, no query to any of the students? No doubt, no question, no query to any of the students? Okay, now, what is the meaning of void contract and void agreement? Do you know the difference between void contract and void agreement? Void agreement means void from start. So void from the beginning. Court will not help me, court will not help you. What is the meaning of void contract, everyone? Void contract means earlier it was a valid contract. Earlier it was a valid contract, but later due to impossibility, it has become void. What is a valid contract? Void contract? Void means it was valid earlier, but now it has become impossible. What if I wanted Lata Mangeshkar, a singer, to sing at my birthday? I gave her some money. Now, before my birthday could come, she passed away. Is the performance valid? Is the performance possible? No. Now the contract has become void. I hired an actor to work in my movie. Before we could start the shooting, he died. The contract was valid before, now it has become impossible. Also, the contract can become impossible because of change in law. In Maharashtra, in Gujarat, alcohol is banned. What if today alcohol is allowed? We enter into contract today. The contract is valid. for 1 year. I tell you that I will supply alcohol to you for 1 year. Okay, we are in the state of Gujarat. But after 3 months of our contract, the government makes a law that now no one will buy and sell alcohol in Gujarat. Now, if the government has made such a law after the contract, earlier it was valid, now it has become void. Is this crystal clear to everyone? Is this crystal clear to everyone? Is there any kind of doubt, question, or query to any of the students? Okay. Void agreement means what? It is void from the start, void from the beginning. Agreement will become contract, right? So at the agreement stage itself, it is void. But void contract means earlier it was valid, now it has become impossible. And that is the reason why it has become void. Impossibility can be because the person has died, was going to sing, his personal skills were being used, or the law has changed. Okay. Now what is the meaning of voidable contract? What is the meaning of voidable contract? Voidable contract means a contract which can be made void. Voidable means it can be made void. I'll give you an example. A commits fraud with B. Okay, and B gives goods to A. B gives goods to A. A commits fraud with B. B gives goods to A. Okay. Now the person with whom wrong has happened is B. We call him as aggrieved party. We call him as aggrieved party. In voidable contract, he has two options: do something or do nothing. If he decides to do something, he will make contract void. He will tell the court that, my lord, he committed fraud. I have proof. The contract will become void. But if he doesn't do anything, how will the court police officer know that A committed fraud with B? If he does nothing, then it will be valid. Make contract void. If we do nothing, it will be valid. Why? Because how will the outsider know that a fraud has been committed with you? How will the outsider know that a fraud has been committed with you? Is this clear? Is this clear? Is this clear? Is this crystal clear to all the students who are watching the session? Is there any kind of doubt, question, query to any of the students? Till here, do you have any doubt? Till here, do you have any question? Do you have any query? Yes. No doubt, no question, no query. No doubt, no question, no query. Now, see, since we are on a very short time, you also have to do self-study, revise at home. I'll tell you some important points for the exam. Okay. Number one. Write those questions which you are sure of first. Then solve those questions which you are not sure of, but you know some points. Okay. Number two, can write answer in own words. Do not change meaning. You can write answer in your own words, but do not change the meaning. Okay. Do not panic if stuck at one question. Just because you are stuck at one question, do not panic. Do not panic if you are stuck at one question. Go on the next question. Is this clear? Is this clear? I hope this session helped you understand certain concepts and certain points which will be helpful for you in examination. I hope you have understood certain concepts and certain points which will be helpful for you to solve the paper properly. Okay? Feel free to ask any doubt while self-studying to me on 9657073003. Also, you can ping me on my Instagram, Professor Shubham Joshi. If you come across any doubt, you can message me on WhatsApp. If you want, you can message me on Instagram. I hope this is crystal clear to all the students. Till here, I've been helpful for you all. And what will we write everywhere? I will become CS in coming attempt. Yes or no? Yes or no? Don't stay up the whole night. Have proper sleep. Drink plenty of water. Carry water bottle with you. Carry a small piece of chocolate with you, so that when you start shaky, once you become shaky or you get scared, have that chocolate. Do you have what it takes? Yes. Do you want to clear the exam in first attempt? Yes. If you want to become a CS, you will study hard, you will study good. Okay. If you come across any doubt, feel free to ask. Okay. Is this clear? Is this clear? With this, I am concluding this session. Focus on TOT. Focus on BNS, Bharatiya Nyaya Sanhita. There is a topic called as stages of crime. Focus on that. Okay. Then criminal breach of trust. Criminal breach of trust is also important. Focus on that topic. Res judicta, res sub judice. Study these topics from CPC properly. Okay. If it is a practical question, your format will be, first you will write provision, then you will write fact, and then you will write conclusion. Don't waste time on writing fact. Fact means what? Part of question or the story. Don't waste time on this. Write only small 2 lines. This is given in question. This has happened. Provision means what? What law says. And conclusion means what? Application of provision in given case. Once the video is over, in the comment section, do give your valuable feedback. The time is less, so I have tried to give you all the important topics, and this is how you will write the answer in practical question. And if it is a direct question, write answer in point form. Okay, write answer in point form only. Write answer in point form only. Okay, write answer in point form only. Okay, feel free to ask any doubts you have. You can contact me. I will be helping you throughout the night if you need any help. Study well, study good. Thank you so much, everyone. Lots of love to you. I pray to Ma Saraswati, I pray to the gods that you pass in this exam. You get the scores that you deserve. You have worked hard. Don't panic. Don't worry. Exams are easy. Exams are not difficult. We get panicked. 60% of the paper goes wrong because of our panic and fear. You have studied, you have worked hard, you will get the result. Failure is part and parcel of life. Don't worry about the result of the examination. Don't even worry about anything. Focus on what is there tomorrow. And once the paper is over, focus on the next paper. Okay? We'll see you. I'll meet you all soon. If you need any help, feel free to contact. Till then, do whatever you want to do, man. Don't trouble Mata, Pita, and Bharat Mata. Okay? Thank you so much, everyone. Your feedback will be very important. So whatever feedback you give in the comment section will be very helpful. Thank you so much. All the very best. Do well. And yes, you are going to pass the exam. Bye-bye. And how's the Josh? It should be high. There should be fire in comment section. Put that fire. Okay. So show it to everyone that yes, I will be clearing the exam. Thank you so much.